Check, check, check. Check. Check, check, check. S1. Check. Check, check. 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 इधर है कुछ?
I was the most crucial aspect of my submission was respect to how we look at Article 368 and the procedure for making a constitutional amendment. So there are three kinds of situations where a court may make a declaration that the legal instrument is void. First is a case where a constitutional amendment is declared void, either because the procedure has not been followed or because of constituent incompetence. What I've coined to make a distinction from legislative incompetence, because 368(1) talks of constituent power. So it has described itself as a constituent exercise. And doctrine of basic structure really means that the constituent power does not contain the power, or it does not enable the Parliament by the special procedure to destroy or emasculate the basic features of the Constitution. So it was a case of constituent incompetence. That would be a case where the provision or entire bill or a particular provision of the bill, in this case, Section 4 and 55, which were introduced by the 42nd Amendment Bill, they will have to be treated as if they were never there. It goes out of the bill. There is a distinction between the procedure of ordinary lawmaking power and 368. Here, the terms of the bill become part of the Constitution itself. The expression, thereupon the Constitution shall stand amended in accordance with the terms of the bill. Because of parliamentary procedure, they say that once it has been assented by the president, it becomes a constitutional amendment act. But 368 doesn't envisage any such thing. The moment the bill is passed and assented, the constitution stands amended in terms of the bill. And in para 75 for Minerva Mill, what was struck down was section 4. As far as we are concerned, section 4 of the bill. And in as much as the declaration would operate retrospectively from the very inception, that is the date when the assent was given by the president. For paragraph 75 of Minerva Mill does not contain any limitation with respect to its declaration. It doesn't say it will not be retroactive or it will be retroactive with certain conditions. Yes, madam.
1 says amendment in terms of the bill after it is passed. Suppose after discussion in the parliament or the legislature, there is some change proposed in that.
Some change in the.
Change proposed in the bill. Some language is proposed to be changed.
I'm sorry, I couldn't get.
Some bill is presented. After discussion in the parliament,
Yes.
some change is proposed.
Yes.
In the language. Now that change is never made in the bill. It will come only in the act. Now the language says in terms of the bill. And the parliament says.
If an amendment is proposed and the amendment is passed by the parliament, it will be treated to be a part of the bill itself then. That's my humble response.
Because the amendment is proposed before the bill is converted into an act.
Yes. So during debate, somebody will move a motion
That shall be deemed to be.
that it, instead of like as we Lordship saw in the Constituent Assembly, there were K.T. Shah and other members, they moved amendments. So before it is put to vote, finally, either the proposer of the bill, or in this case the government, they will, somebody who is moving the bill will accept it, or it will be referred to select committee. It will go there and come back with a recommendation. So the bill will be ultimately passed either defeating the amendment or not approving the amendment, and then it becomes part of the bill itself. Therefore, that once it is declared by the court do not have legislative power, there is not repeal. All these things are actually completely foreign to the structure and phraseology of Article 368. They don't fit in there. Either the Constitution stands amended or it does not stand amended. These are the two situations only. Once the declaration is of its void, then we should not to adopt the principle of East End dwelling. Should not allow the mind to boggle. Just because there is a gap in the proceedings of the court and the declaration comes after a certain period of a certain lapse of time. This case, Minerva Mill's case, 9 years time. So certain things happen. Court may save it. Court may say it will be retroactivity, but whatever has been done will not be disturbed. Or as in Indra Shani's case, the Lordship still went a little further in crafting. So the court today acts scientifically like a surgeon. It may involve grafting. As in Indra Shani, Lordship said, it's promotions reservation in promotion not permissible, but this will operate 5 years hence. So from a later date. So as I said in Golaknath, where they propounded the principle of prospective overruling, that the courts, we should shed the impression that the courts do not make law. The courts do make law. And the very doctrine of basic structure is something which has emerged from the pen of the court. So the courts are making law. Interregnum legislation, interstitial legislation, filling in the gap. There are so many forms in which the court today is, and very rightly moves,
Shortly put, it is called judgment law.
in judgment law. So therefore,
Sometimes as a critique.
now, Lord, to bank upon Keshav Madhav Menon and all those earlier cases in the 50s, Peshi Kaka and so on, to hark back to those and bring them back on the table for discourse. Today, it's well accepted, well entrenched that the courts do make law. And so therefore, the courts, if the court can say that our declaration will not operate backwards, it will save something, it will be treated as if in the past it was operating. Lordships can say that until this date it operates, but hereafter it will not, because we have declared it to be void. So all these things show that once the declaration is there, that declaration operates, in this case, being unrestricted, unqualified, it will go back to the root. It is as if it was never there. It is as if the Constitution never stood amended in terms of Section 4 of the 42nd Constitutional Amendment Bill. So this is constituent incompetence. Now this stands on a stronger footing than legislative incompetence, where the state legislature or parliament may trench upon the exclusive field of the other legislature. Even in that case, all these judgments which my learned friends have referred, even though they are of the 1950s, they have took caution to say that if the defect is of legislative incompetence, and I'll show that when I refer to those judgments, then they are void ab initio, of no effect. So this court has distinguished between a case of legislative incompetence and while an invalidity arising out of breach of either fundamental rights or some other constitutional provision.
Article 368 specifically refers to constituent power.
Yes.
I think that is why you are coining the phrase constitutional incompetence. Constituent incompetence. Now, legislative incompetence, you are differing. And is it because one is trying to make a change or variation in the constitution, or is it because the other exercise is in respect of a legislation you are making the difference, or there is any other constitutional apart from the words used in Article 368?
Yes, I'm grateful. The reason for my making this distinction is that in the case of a law being passed, as the procedure prescribed in 196 to 200, Article 196 to 200,
Yes.
even in these articles, your lordship will not find the word act. The bill is passed, goes to the governor or the president and assented. But in Article 123 and 213, which is ordinance making power, there is special mention that once the ordinance is passed, within 6 months, it must be placed before the houses and converted into an act. So therefore, there the position is that the legislative amendment, once it is passed, it itself becomes a statutory provision and act. Here the Constitution stands amended in terms of bill.
Bill has to be introduced in the Parliament to be
There
passed.
the Amendment Act is an act by itself. It's another matter that in the publications we find that that is incorporated. And at the foot you'll also find that that is an Amendment Act inserted by this Amendment Act. But that amendment is a separate independent enactment which then inserts itself into the main enactment. Not a matter of great substance, but this is a distinct procedure there. There is no provision which says that the moment the bill is passed, the original act will stand amended in terms of the bill. So this is a very potent expression. Mr. Nariman, Pali Nariman employed this expression for getting the reference. And I am banking on that very expression for a different conclusion. What he wanted to say was that once the bill is passed, then it becomes incorporated. The earlier provision is gone forever. It will not return. That was his logic.
You are using Nariman's Gada for another purpose.
Yes. The Gada is there in 368. But we are swinging it in different directions, one on the right, one on the left.
But on the third situation, of course, is the second was legislative
And
incompetence.
the third is where the
Violative
law
of fundamental
is
rights.
breaching the fundamental rights or some other constitutional limitation, like in Article 286.
Now, 13.2 says that any law which is in breach of Part 3 is void. So how is that voidness distinguished from a law which is void on the ground that, or an act which is void on the ground that it is in breach of the basic structure?
So on 13, there is some divergence in the judgments of this court. Initially from case.
Constitutional amendment,
Only to a law.
even it's three.
So constitutional, this Keshav Madhav Menon, Peshi Kaka, and Sundararamayar. Sundararamayar was dealing with breach of Article 286. So the cases from Keshav Madhav Menon up to Peshi Kaka, they were dealing with Article 13(1), which is existing law, which continues by virtue of Article 372. And since it was a law made before the advent of the Constitution, it will never be void from inception. So it becomes void with effect from the date when the Constitution was made and to the extent of inconsistency. Article 13 in both 13.1 and 13.2 says to the extent of inconsistency, which will always be the case. So the doctrine of eclipse, etc., came into play.
Yes.
Now, in that respect, there is no difference between 13.1 and 13.2. Both say to
Void.
the extent of inconsistency, void. But because of the very nature of 13.1, the laws which are being considered being of the past, therefore, it is said that the law remains on the statute book. It is good for the past. Second, if the breach is of Article 19, now that's another feature that these cases are dealing with cases of breach of Article 19, which is limited to citizens. That's a right conferred exclusively on citizens, not on non-citizens. And companies are not citizens, as the law stands. There is some debate on that because of the wide range of activities which the companies today are regulating and operating on. But keeping that aside, the 19 is limited to citizens. So the debate was that even if the law has been declared void on the ground of 19(1)(f), that was Balsara. And that's how it was Deshikaka emerged to find out what is the effect of the declaration. So it is said that even if, though it is non-existent, ineffective, unenforceable with respect to citizens, because their rights have been affected and found to be and declared to be void. But with regard to non-citizens, it survives and remains on the statute book, therefore. So these observations which the petitioners want to deploy, Lords, are completely in a different context where fundamental right under Article 19, which is limited to citizens, is impacted. And consequently, a distinction between citizen and non-citizen surviving qua non-citizen. And this is where Ambika Mill's case said that if in such a situation, the laws covered by 13(1) would survive qua non-citizens, it would equally survive qua the citizens, qua the non-citizens in case of 13(2).
Sorry?
If the law survives on the statute book, qua non-citizens, in the case of Article 13(1), the same would be the position with regard to Article 13(2).
It doesn't make a difference.
That is what Justice Matthews says, that even with regard to 13(2), if there is a breach of Article 19, which is limited to citizens, so there can't be a different result. So that is a debate, my lord, which is centering on this citizen, non-citizen difference, which is limited to Article 19. Yesterday, my lord, the Chief Justice asked me about what would be the position if there is a breach of Article 14, 20, 21. Now, they are not limited to citizen. This differentiation and this consequence over which there is a debate would not be there in case of breach of 14 and 19.
There's a breach of 14 or 21.
It would be void ab initio, that the result is same. Because fundamental rights are also imposing an incapacity on the legislature in a different way. My fundamental right is a restriction, a limitation on the competence, unless they justify as a reasonable restriction in the various heads. Or otherwise, on the various parameters which have been declared by lordships, qua Article 14 or 21. There are none of the fundamental rights are absolute. So there are certain criteria to judge the law. That test has to be passed. And today they don't stand in independent silos. Therefore, each of wherever the impact is, wherever the effect falls, that fundamental right, that test has to be.
Therefore, in other words, according to your submission, a law which is in breach of Articles 14 and 21 would suffer from the same consequence as a constitutional amendment, which is in breach of the constituent incompetence, or which is in breach of the doctrine of constituent competence.
Yes.
That is, it either vitiates the procedure which is spelled out in 368, or alternately, it violates the basic structure.
So I would bring it at par with legislative incompetence, because we are dealing with the legislative law. The constituent power stands on its own. It's a standalone provision, Article 368, which will be judged on the anvil of 368, what is the effect. But legislative incompetence arises on two aspects. One is that you have to have the subject matter in your field. And the second is that you should be on the right side of the various provisions of the Constitution. What you cannot do under the Constitution, any provision of the Constitution, beyond you. So the resultant is same. The only debate arises under 19 because of citizen, non-citizen, which in my respectful submission, Mirror, once the court is declaring a provision under 13(2) as void, then it is up to the court, unless the court says that we are making this declaration and limiting it to the citizens alone, the declaration of voidness will have full play. This aspect has not been considered in Sundara Ramayar. And Mahendra Lal Jaini's case is right.
Have you captured this part of your submissions in your note?
Yes.
Mr. Trivedi?
I have Mulatu.
Just also like to read along a
Yes.
little bit.
So when Ambika Mill says that even in the case of 13(2), the law would survive for non-citizens, that would be a matter for the court's declaration. That's my humble submission. When the court is declaring the law as void, being in breach of 13(2), it's for the court to declare. For there may be so many laws which may not be applicable to non-citizens, may be applicable only to citizens. Then why should that consequence?
So it is for the court to either save
Yes.
all the consequences of the declaration of voidness or give it untrammeled effect,
Trammeled effect.
which the court will say everything goes.
Yes.
The court may say, well, we'll do it prospectively, or that we will save transactions which have taken place under the law.
Or defer.
That it has a variety of options open.
That's a variety of options. The power of declaration, doctrine of ultra vires gives wide power.
So if third-party rights have taken place under the law, say people have been regularized under a law which is found to be void, may say that it will not affect the consequences which have already emerged, so that we don't want to displace the creation of third-party rights or third-party entitlements which have ensued under the law.
So if the declaration is absolutely wide, then it would not lie in the mouth of any authority or any person to say that we will read the whole judgment and see that it was challenge was made by a citizen and the fundamental right was.
Question which arose before the 7-judge bench in the Ordinances case. What happens when an ordinance
Yes.
is either held to lapse or an ordinance is held to be a fraud on power? What happens to the consequences which took place when the ordinance was in operation? One view was that, well, those consequences survive because they were made by a constitutional authority which had the power to make that ordinance.
Yes.
So we applied the test of public interest.
Yes.
Justice Gajendra Karkar took a very clear view in the sense that he said everything which was done would survive. So we took a more nuanced view in Krishna Kumar Singh and said that it depends upon how the court perceives it. You may apply the test of public interest and save consequences even under an ordinance which has otherwise been held to be void or to have lapsed.
But back to,
The
And
lordships,
of course,
yes.
your lordships went to the extent of saying that the ordinance making power does not contemplate creation of a permanent state of affairs. Because the ordinance has to be placed before the House, then the House can disapprove it, and then the executive can never say, I have created a permanent state of affairs. To hell with it, whether you have passed it or not passed it or approved or disapproved. So parliamentary democracy demands that will prevails.
Because it is an exception to the lawmaking power of the
Yes,
legislature
ma'am.
or the parliament.
Yes,
So there can't be an ordinance, Raj.
yes. My Lord, the Chief Justice rendered the judgment in that
Interpreting was it as-
Krishna Kumar Singh's case. So it is better to leave it to the court, and not to the authorities and then later on to say that even though you have
your
declared it void.
submission then in summation is this, that what following the declaration of section 4 being null and void in para 75 of Minerva Mills,
Yes.
it is as if that the bill which proposed to amend the constitution was stillborn. It was never
contained
attained.
section 4.
It never attained the status of a bill which was validly passed,
Yes.
and therefore, once that is effaced, the original provision of Article 331C was never, in that sense, substituted. The substitution never took effect,
Yes.
according to you.
So doctrine of basic structure goes to the very first step, introduction of the bill. They don't have any power to introduce a bill which amends, seeks to destroy the basic feature.
But who is to say that
Court will say this.
later?
Later, your lordships have said in Keshwanan that on a case-to-case basis, your lordship will decide.
Point now. Would you like to just show us, as my learned brother, Mr. Rishikesh Roy was asking, the note which you would like to just read out that, how you have formulated it?
Which volume and which? Volume 2N, my lord, deals with this part. If I may just draw my lord's attention before reading, my lord, to one more aspect of it, that 368 says that in terms that you may amend by addition, variation, or repeal. Even if these words were not there, the word amend will include all these forms. But they did not leave it for implication, expressly mentioned. Now, this is an additional alternative submission that in this case, we have to look at the nature of section 4. As my lord the Chief Justice said, that it was a case of expansion, enlargement. So the intent was not to, the intention of the Parliament in introducing 42nd Amendment Bill was not to simpliciter repeal 31's unamended 31C. The intention was to add, to bring in some more directive principles for the entirety of Part 4, in addition to 39B and C. So section 4 is a substitution by addition. It will not be a case of variation, because variation would mean putting 39B and C in some different way. If the same thing is to be put in a different way, then that would be variation. But if A plus B, then it is to be C plus D and E are also to be brought in. That's a case of addition. So the result of declaration would be that the addition goes. And this aspect, Lord, has been brought out in the case of tobacco, what's international tobacco, Indian tobacco. That is volume 5A, page 3218. to 17 at page 3223,
Way.
volume 5A, page 3218, and the relevant portion is at page 3223. It's a case of repeal of repealing act. The context of a tax on sale of cigarettes,
3233.
3223.
3223.
Para 14 to 17. Yeah, please.
Yes.
The ratio of the two separate but concurring judgments of the appellate bench of the High Court is that the 1954 Act had the effect of completely repealing the 1941 Act in relation to cigarettes. And the repeal of 1954 Act in relation to cigarettes by the 1958 Act did not revive the operation of 1941 Act in regard to cigarettes on the principle that the repeal of repealing Act does not revive the repealed Act. Since the 1941 Act stood completely obliterated from the statute book in relation to cigarettes, no sales tax would be payable in regard thereto, either under the 1954 Act or under the 1941 Act. Upon these premises, it was held that the company as a dealer in cigarettes and smoking mixture is not entitled to any certificate of registration under the Act of 1941, as it is neither a dealer within the meaning of that Act nor liable to pay tax. The general rule of construction is that the repeal of a repealing Act does not revive anything repealed thereby. But the operation of this rule is not absolute. It is subject to the appearance of a different intention in the repealing Act. Again, such intention may be explicit or implicit. The questions, therefore, that arise for determination are whether in relation to cigarettes, the 1941 Act was repealed by the 1954 Act and the latter by the 1958 Act, whether the 1954 Act and the 58 Act were repealing enactments, whether there is anything in the 1954 Act and the 1958 Act indicating a revival of the 1941 Act in relation to cigarettes. It is now well settled that repeal connotes abrogation or obliteration of one statute by another from the statute book as completely as if it had never been passed. When an act is repealed, it must be considered except as to transactions passed and closed as if it had never existed. Repeal is not a matter of mere form, but one of substance, depending upon the intention of the legislature. If the intention indicated expressly or by necessary implication in the subsequent statute was to abrogate or wipe off the former enactment, wholly or in part, then it would be a case of total pro tanto repeal. If the intention was merely to modify the former enactment by engrafting an exception or granting an exemption or by super adding conditions or by restricting, intercepting or suspending its operation, such modification would not amount to a repeal. Broadly speaking, the principal object of repealing is to excise dead matter purna of superfluities. So what I rely upon is this, that please look at the intent of the assembly when they were introducing section 4. What was the intention?
So for instance, to take your line of argument further, when they substituted the words, the principles contained in Articles 39 B or C, they said all or any principles
Yes.
in part 4. What Parliament was intending really was to do this, according to you. Suppose they had said, instead of 39 B and C, they had said 38, 39, 39A, 40, they produced all the provisions of the directive principles, right? Including 39B and C. And that was invalidated by Minerva Mills. 39B and C would still stand.
Still stand.
Because, that had been upheld in Keshwanand. So instead of physically enumerating all the provisions of the directive principles, namely 38 to 38 to 51. What they did was they said all or any of the principles in part 4. So does that make much of a difference? If they had done the former, obviously it couldn't have been argued that, the entirety went, because they would have struck down everything but 39B and C. So the fact that instead of physically enumerating all the articles in the directive principles, Parliament used a catch-all phrase, all or any principle, should really not make any difference according to your submission.
So
Because that was the intent. The intent was to expand.
Yes. And that intention cannot be ignored. That's the primary thing, very important aspect.
A substitution, in a sense, also involves some degree of repeal. Because when in exercise of the constituent power or the legislative power, the legislature is substituting a provision, it is also implicitly repealing a provision. Because you are substituting in the sense you are repealing the earlier provision and bringing a new provision in it.
So it's, as I said, Milord, once we bring in the intention, we have to see there are substitutions and substitutions. There can be a substitution by addition, substitution which is intended to vary, substitution which is intended to repeal.
A substitution may be of a completely new provision.
Completely new provision.
You want to completely obliterate an erstwhile provision.
Yes.
And bring in a new provision which doesn't even deal with the same subject matter.
So the amendment bill could have said that Article 32C is repealed. And then would have said that we are inserting something else in its place. Instead of splitting up this substitution, dehorse the context of Section 4 and saying that it involves two steps, split it up. One is erasure and other is insertion. And therefore it is subsumed. Now this theory of split up and subsuming militates with the context of Section 4. The purpose, the intent of Section 4, quite apart from the fact that in terms under 368, it will mean that it never happened. So even if we treat it that it became part, the only thing which goes out is what was added.
Now, what is the next? Anything else now remains in your submission?
Now, there was one in this context, there was a reference to an earlier exercise which Parliament, Lord, it is said, wanted to reduce. But Rajya Sabha,
they wanted to bring it in conformity with Keshwanand. But the bill never passed the Rajya Sabha.
never passed. So in the first case, when they inserted 32C expanded, so they were emboldened by Keshwanand Bharati that it has upheld 39B and C, so we can now have the whole of it. So completely shut out, avoid the courts completely, no scrutiny.
Then they wanted to bring the amended 31C back to the pre-amended.
But the Rajya Sabha said, no, why reduce the powers which we have gained? But that is all prior to the declaration by the court.
And ultimately, that will not affect.
That is only irrelevant.
The legislature wanted to do. There may be a variety of reasons why a bill lapses. Maybe the Parliament, of course, this was the Rajya Sabha, but in a given case, the term of that legislature, the lower house may come to an end. The government of the day may not have the majority in the Rajya Sabha in the case of the Rajya Sabha, but that shouldn't affect how we construe the provision. We'll have to construe it independently.
They could have a thought also.
Isn't it, Rishi? And
It's another matter that had they accepted that amendment, perhaps it would not have been necessary for the court to go into it. Because it's reduced. They would have only just examined nothing because Keshwanand Bharati has already upheld 30, unamended 30. So there was nothing. So of course they did not want to give up, and your lordships made them give it up. In Minerva Mill, when your lordship struck it down. So what they did not do it, the court did it. Now kindly have just two, three cases only on that point which I am building up. That is the Sundara Ramayar. All these cases have expressly said that if it is incompetent legislatively, it's of no effect. And in fairness, the petitioners did not say that in a case of legislative incompetence, it will still remain on the statute book. An incompetence case, never bring it on the statute book at all. Volume.
Page.
At page 421. So this was a case. So if your lordship accepts my first two submissions which I have made, then Lord, it may not be necessary to go into this debate about 13.1, 13.2, etc. It doesn't arise directly in our case. But since it has been raised and made, the principles have been tried to be lifted up and utilized.
By them.
Yes.
After a provision is struck down by the Constitutional Court, any provision of the Constitution or maybe some act also, that attains finality. Is there automatic change in the act also? Because this is never made. You have seen the Keshwananda also. We have seen your L. Chandra Kumar. There are a lot of, you don't see those changes in the Constitution. They are bound to do it or not? Or is it automatic?
Revival.
Not revival. Provision is struck down. Whether the Constitution is deemed to be amended to
In
that,
my respectful submission, the statute stands corrected as it is, once your lordship declares.
it has to be.
Then
Shall be deemed to be
I'm not
deleted.
aware of a single act which this court has declared or any high court has declared ultra virus where the legislature has proceeded to pass an act to remove it from the statute.
Yes, we have not seen that.
So subject to my lord, correction from my learned.
We have also not seen that. These are still there. in the
Never done, my
statute.
lords. And I'm grateful for this question, Lord. The Parliament has never passed, the legislatures, no state legislature has ever passed. They abide by the dictum of the court, and that's because of the mandate of the Constitution flowing from Article 136, 141, 142, and more importantly, 144, which specifically says that all civil or authorities will have to
Abide by.
act in aid, very strong word, act in aid of the Supreme Court.
That doesn't create an anomalous situation. Somebody sees now.
So there's no anomaly at all. Lord. The Parliament never does it in India. We don't need to go abroad, cross the 7 seas, Lord, and find out what America is doing or what UK is doing, what they feel like.
Parliament had not been doing, whether it should be done or not.
And they have also not created any, Lord, Taj Mahal, where all these dead acts, Lord, can be placed as a mausoleum, Lord. So it goes, it's gone.
No, only when an amending act, after the amendment is made and it comes to the statute, then the amending act is repealed.
Amending Act.
Amending act is repealed. That is all become dead wood.
That is a kind of.
That exercise the legislature does.
Once they incorporate it,
Yes,
but that's a meaningless. But once the court declares void,
that's
I
a
have
judicial verdict,
not
unless
subject
they
to
remove the
correction.
basis of the judgment
Your
and
worship is right.
pass another validation.
No, but they do it. They do it. That's to remove the clutter.
Yes.
That is only removing the clutter, Lords. That is not a dead wood, since it has been incorporated. Therefore, but the dead wood which is resulting from the declaration of the court, I have not come across, Lord, subject to correction, Lord, if there is. And that is of no effect. One more aspect.
It gets effaced from the constitution or from the
Yes.
statute.
It's not simply unenforceable. No.
Actually.
There was one other, Lord, I'm grateful for the question. There was one other aspect which the petitioners presented, and that was that since after declaration of voidness, it remains on the statutory parchment, and it's not a case of repeal, the court cannot repeal it, only Parliament can repeal it, and therefore there can't be two provisions on the statute book side by side. Now this may sound attractive, Lord, but what really is happening is there will never be a case of two provisions on the statute book. One is alive, the other is dead. And in our society, Lord, where being and becoming is a process which continuously goes on, people getting born, people dying. So the living and the dead are part of this world. So every living organism, which the Constitution is. So therefore, this is nothing strange, Lord, that there is a provision. I'm assuming the worst case scenario that something is remaining there unenforced. So there is nothing militating. There is no inherent contradiction between a revived, alive provision and a provision which is dead, having been declared by the court of law to be so.
That only.
We have cemeteries, Lord, so it can lie there dead. No problem. We have to look at what is operating. Sorry, boss.
There is one more question on that. Now, it is at the option or free will of the publisher only what to publish in the book. Or some provision is struck down.
I'm sorry, Murali.
Any provision is struck down by the Supreme Court, finally,
Yes.
right? One is that 144 says everybody will come in aid. So whether in that context, the Parliament or the state or the Parliament, in Constitution or the central statutes or the state statutes, don't follow that mandate by amending the act, because they are to come in aid, number one. Number two, it's the free will of you see this Constitution, you must have a copy of it.
Yes, my friend.
Article 323A, 2D, struck down by this court. Chandra Kumar. 323 A2D. This is at page 310.
323B.
2D. Judicial review.
Exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136.
This was struck down in Alchandar Kumar.
Yes.
This book doesn't mention it.
So these are the publications.
This is what I'm asking. It is at the free will of the publisher only. No, how the layman will come to know? He will not search the law for anything.
The publisher should not include what is struck down.
Any note, anything, no, nothing is there. 323B, 3D also says.
The note is below, after the entire provision at page 313, if your lordship. That's correct.
Book.
Layman, but then we'll be out of business.
Mr. Shankara, but one thing to your credit, if you see a little bit of what's happening in this time of the year, I've noticed that your book of the Constitution, your means the one which is edited by you,
At the end
is
of the.
bandied around quite a bit of late. So you might take credit for it.
At the end of the section.
Others also.
At the end of the provision.
My friend has presented to all of us.
Publication also, nothing is mentioned.
Nothing. Under 144, they should have complied.
Published by the Government of India in 2015.
So these are executive exercise of publications.
This is, the
They
question
should
is that
do.
only. If 144 is there, why don't they come in aid and give effect to the judgment?
Yes, they
It is
should.
giving effect to the
At
judgment.
least they should mention somewhere boldly that it doesn't survive.
Why can't they make the act only of constitution corrected as declared by this?
They should do it. All right.
Will it come in the legislation, directing a legislation?
In the universal publication word, in the footnote, they have mentioned,
Yes, in some books it is there, some books it is.
some it doesn't. But what they should be doing is that they should eliminate it from there.
Yes.
And in the footnote, they should provide that this was the provision which has been struck down.
It should be based on this.
So that one reads it.
This is the automatic act.
And in order to protect their skin, if they are to be questioned, that so-and-so council had suggested that this is how it should be done.
Kindly have this verse.
At some point of time.
With Article 286.
286.
So they said that the Act 286 doesn't say that a law which contravenes 286 is void. So he says the law was valid as to a part which was enforceable. Then that cloud was lifted, and therefore it became valid in its entirety once the bar under 286
So
was lifted.
United Motors upheld the provision. Bengal immunity then took
They
a different
distinguished
view.
Pesikaka and Dhakras
All are
on the ground that
discussed.
they dealt with Article 13.
Yes.
Actually, there are three extracts there which are important: 421, 427, 428, and 429.
Absolutely right. That 421.
Just it.
My. May I just,
At 421,
may I place it?
yes.
Now, in considering the question as to the effect of unconstitutionality of a statute, it is necessary to remember that unconstitutionality might arise either because the law is in respect of a matter not within the competence of the legislature, or because the matter itself being within its competence, its provisions offend some constitutional restriction. In a federal constitution where legislative powers are distributed between different bodies, the competence of the legislature to enact a particular law must depend upon whether the topic of that legislation has been assigned by the Constitution to that legislature. Thus, a law of the state on an entry in List 1, Schedule 7 of the Constitution would be wholly incompetent and void. But the law may be on a topic within its competence, as for example, an entry in List 2, but it might infringe restrictions imposed by the Constitution on the character of the law to be passed, as for example, limitations enacted in Part 3 of the Constitution. Here also the law to the extent of the repugnancy will be void. Thus, a legislation or a topic not within the competence of the legislature and a legislation within its competence but violation of constitutional limitations have both the same reckoning in court of law. They are both of them unenforceable. But does it follow from this that both the laws are of the same quality and character and stand on the same footing for all purposes? This question has been the subject of consideration in numerous decisions in the American courts, and the preponderance of authority is in favor of the view that while a law or a matter not within the competence of the legislature is a nullity, a law on the topic within its competence but repugnant to the constitutional prohibitions is only unenforceable. This distinction has a material bearing on the present discussion. If a law is on a field not within the domain of legislature, it is absolutely null and void. And a subsequent cession of that field to the legislature will not have the effect of breathing life into what was a stillborn piece of legislation, and a fresh legislation on the subject would be. So even subsequent conferment is unhelpful. But if the law is in respect of a matter assigned to the legislature, but its provisions disregard constitutional prohibitions, though the law would be unenforceable by reason of those prohibitions, then once they are removed, the law will become effective without reenactment. Then leaving the rest, if your lordship has.
Now you can go to 427, actually, the bottom of
Yes,
427.
Peshikaka and all are dealt with in page 424.
And on the discussion at 427 after dealing with Peshikaka and
427 bottom.
yeah, the result.
The result of the authorities may thus be summed up, where an enactment is unconstitutional in part but valid as to the rest, assuming of course that the two portions are severable. It cannot be held to have been wiped out of the statute book, as it admittedly must remain there for the purpose of enforcement of the valid portion thereof. And being on the statute book, even that portion which is unenforceable on the ground that it is unconstitutional will operate proprio vigere when the constitutional bar is removed. Please mark this. It's not a general statement. In this case, what happened was that Parliament had imposed a restriction. Under 286, Parliament specifies, supposing that special goods of importance, 4% will be the tax. Now the state legislature makes some law and had said that as and when the limitation is removed, it will be something different. Now once the Parliament removes, it starts operating automatically. That was the position here.
Then you can see the bottom of page 428, that will be important because
The fact that it is invalid.
the bottom of 428, the last paragraph. Oh, you're on 428, right?
Yes.
That before you leave the last para, about 10 lines from the continuing para, the result, yes, the fact that, yes.
The fact that it is invalid as to a part has not the effect of obliterating it out of the statute book, because it is valid as to the part and has to remain in the statute book for being enforced as to that part. The result of the enactment of the impugned act is to lift the ban under Article 286(2), and the consequence of it is that the portion of the explanation which relates to sales in which property passes outside Madras, but the goods are delivered inside Madras, and which was unenforceable before, became valid and enforceable. In this view, we do not feel called upon to express any opinion as to whether it would make any difference in the result if the impugned provision was unconstitutional in its entirety. This is very important. So even 286.
And now last para there, 428, that then sums it up.
There is one other aspect of the question to which reference must be made. The decisions in Peshikaka and Bhikaji Dhakras both turn on construction of Article 13, which enacts that law shall be void to the extent they are repugnant to the provisions of Part 3. We are concerned in these petitions not with infringement of any of the provisions of Part 3, but of Article 286(2), and the point for our decision is as to the effect of the infringement of that provision. Article 286(2) does not provide that a law which contravenes it is void, and when regard is to be had to the context of that provision, it is difficult to draw the inference that.
And now you can just see the last sentence of that para, whether we consider the question on broad principle
as to the effect of unconstitutionality of a statute or on the language of Article 286(2). the conclusion is inescapable that Section 22 of the Madras Act and the corresponding provisions in other statutes cannot be held to be null and void and non-est by reason of their being repugnant to 286(2) and the bar under that article having now been removed. So the substance.
The argument was that now that the bar was removed, Parliament has enact a fresh law. This was not necessary, they said, to enact a fresh law. The bar was removed and therefore they could.
Therefore, it starts operating. But they took caution that if in some case it is entirely, then it doesn't matter really whether the provision calls it void or not. If a constitutional prohibition anywhere residing.
So really speaking, your argument places the violation of the basic structure on the same pedestal as a law which is lacking in legislative competence. So that it is then never, it's null and void.
Null and void.
And it is never deemed to have entered the statute book at all.
Absolute nullity. Now this was again considered in Deepchand. Annexure 22 of volume, this is not in that big compilation. It's in volume 2. Volume 2, N,
Page?
at page 1027.
What is the judgment?
Deepchand.
Deepchand.
Yes. All constitution benches.
54. Yeah.
At page 1036. And here para 14 and 15, 1036. It is therefore manifest that in the construction of the constitutional provisions dealing with the powers of the legislature, a distinction cannot be made between an affirmative provision and a negative provision. For both are limitations on the power. The Constitution affirmatively confers a power on the legislature to make laws within the ambit of the relevant entries in the list and negatively prohibits it from making laws infringing the fundamental rights. It goes further and makes the legislative power subject to the prohibition under Article 13(2). Apparent wide power is therefore reduced to the extent of the prohibition. If Article 245 and 13(2) define the ambit of the power to legislate, what is the effect of a law made in excess of that power? The American law gives a direct and definite answer to this question, fully in its constitutional limitations under the heading consequence if statute is void. Skip this one, Willis and Willoughby and all are quoted. Section para 18. Then they consider right from Keshav Madhav Menon, all cases. Para 18 at page 1039. We shall now proceed to consider the decisions of the court to ascertain whether the said principles are accepted or departed from. That's the American principles. First is Keshav Madhav Menon is there, and then para 20 is Peshikaka. Sagir Ahmed, and then para 25 if your lordship has. at page 1048. Please come to page 1049 towards the middle. The result. Sentence beginning, the result of the aforesaid discussion may be summarized in the following propositions. One, whether the Constitution, Lordship got this portion? The result of the aforesaid discussion may be summarized in the following propositions. One, whether the Constitution affirmatively confers power on the legislature to make laws subject-wise or negatively prohibits it from infringing any fundamental right. They represent only two aspects of want of legislative power. The Constitution in express terms makes the power of legislature to make laws in regard to entries in the list of 7 schedules subject to the other provisions of the Constitution, thereby circumscribes or reduces the said power by the limitations laid down in Part 3 of the Constitution. It follows from the premises that a law made in derogation or in excess of that power would be ab initio void wholly, or to the extent of the contravention as the case may be. 4. The doctrine of eclipse can be invoked only in the case of law valid when made, but a shadow is cast on it by supervening constitutional inconsistency or supervening existing statutory inconsistency. When the shadow is removed, the impugned act is freed from all blemish or infirmity. Applying the aforesaid principles to the present case, we hold that the validity of the act could not be tested on the basis of the Constitution, but only on the terms of the relevant articles as they existed prior to the amendment. Kindly have Mahinder Jaini's case, which is volume 5. I'm sorry, it is the same volume at page 157. Para 21 at page 172. We may in this connection also refer to the difference in the language and scope of Article 31 and 13.2. Article 13.1 clearly recognizes the existence of pre-existing laws in force in the territory of India immediately before the commencement of the Constitution, and then lays down that in so far as they are inconsistent with the provisions of Part 3, they shall be void to the extent of such inconsistency. The pre-Constitution laws, which were perfectly valid when they were passed, and the existence of which is recognized in the opening words of Article 13.1, revive the removal of the constituency in question. This effect is doctrine of eclipse, if we may say so with respect, was applied in Bhikaji Narayan case. Article 13.2, on the other hand, begins with an injunction to the state not to make a law which takes away or abridges the rights conferred Part 3. There is thus a constitutional prohibition to the state against making laws taking away or abridging fundamental rights. The legislative power of Parliament and the legislatures of the state under Article 245 is subject to the other provisions of the Constitution, and therefore subject to Article 13.2, which specifically prohibits the state from making any law taking away or abridging the fundamental rights. Therefore, it seems to us that the prohibition contained in Article 32 makes the state as much incompetent to make a law taking away or abridging the fundamental rights as it would be where law is made against the distribution of powers contained in the 7th schedule to the Constitution between Parliament and the legislature of a state. Further, Article 13.2 provides that the law shall be void to the extent of the contravention. Now, contravention in the context takes place only once when the law is made. But the contravention is of the prohibition to make any law which takes away or abridges the fundamental right. There is no question of contravention of Article 13(2) being a continuing matter. Therefore, where there is a question of a post-constitutional law, there is a prohibition against the state from taking away or abridging fundamental rights. And there is a further provision that if the prohibition is contravened, the law shall be void to the extent of the contravention. In view of this clear provision, it must be held that unlike a law covered by 13(1), which was valid when made, the law made in contravention of the prohibition contained in Article 13(2) is a stillborn law, either wholly or partially depending upon the extent of contravention. Such a law is dead from the beginning, and there can be no question of its revival under the doctrine of eclipse. A plain reading, therefore, of the words in Article 13(1) and 13(2) brings out a clear distinction between the two. 13(1) declares such a pre-constitutional law as are inconsistent with fundamental rights. 13(2) consists of two parts. The first part imposes an inhibition on the power of state to make a law contravening fundamental rights. Second part, which is merely a consequential one, mentions the effect of the breach. Now, what the doctrine of eclipse can revive is the operation of a law which was operative until the Constitution came into force and had since then become inoperative either wholly or partially. It cannot confer power on the state to enact a law in breach of Article 13(2), which would be the effect of the application of the doctrine of eclipse to post-constitutional law. Therefore, in the case of 13(1), which applies to existing law, doctrine of eclipse is applicable as laid down in Bikaji Narayan. But in case of a law made after the Constitution came into force, it is Article 13(2) which applies, and effect of that is what we have already indicated, and which was indicated by this court as back as Sagir Ahmad. Then they go on to explain law that Keshava Madhavan, etc. And the last, the next case was the Sambika Mills, which they rely. But in my note at page 10, I'll mention that later on. I'll complete afterwards.
Mills, volume.
Same volume, annexure 8, page 202. It refers to Sundara Ramaiah, Deepchand, etc., but it's necessary to read it to show how now Ambika Mills is trying to move slightly away from. In Sundara Ramaiah, Justice Venkatrama Iyer said that a law made without legislative competence and law violative of constitutional limitations on legislative power were both unconstitutional and both had the same reckoning in a court of law, and they were both unenforceable. But it did not follow from this that both laws were of the same quality and character and stood on the same footing. Proposition laid down by the learned judge was that if a law is enacted by the legislature on a topic not within its competence, the law was a nullity. But if the law was on topic within its competence, but if violated some constitutional prohibition, the law was only unenforceable and not nullity. In other words, law, if it lacks legislative competence, was absolutely null and void, and a subsequent session of the legislative topic would not revive the law which was stillborn, and the law would have to be reenacted. But a law within the legislative competence but violative of constitutional limitation was unenforceable, but once a limitation was removed, law became effective. The learned judge said that the observations of Justice Mahachan in Peshikakal's case, that quae citizens, that part of section 13B of the Bombay Prohibition Act which had been declared invalid by this court had to be regarded as null and void, could not in the context be construed as implying that the impugned law must be regarded as non-est so as to be incapable of taking effect when the bar was removed. He summed up the result of the authorities as follows: where an enactment is unconstitutional in part but valid as to the rest, assuming of course that two portions are severable, it cannot be held to have been wiped out of the statute book. It admittedly must remain there for the purpose of enforcing the valid portion thereof, and being on the statute book, in that portion which is unenforceable on the ground that it is unconstitutional, will operate proprio vigere when the constitutional bar is removed. In Deepchand, it was held that a post-constitutional law is void from its inception, but that pre-constitutional law, having been validly enacted, would continue in force so far as non-citizens are concerned after the Constitution came into force. The court further said that there is no distinction in the meaning of the word void in Article 13.1 and 13.2, and that it connoted the same concept, but since from its inception the post-constitutional law is void, the law cannot be resuscitated without reenactment. Justice Subbarao, who wrote the majority judgment, said after citing the observations of Justice Das, Acting Chief Justice, in Keshav Madhav Menon, the second part of the observation directly applies only to a case covered by 13.1. For the learned judges say that the laws exist for the purpose of pre-constitution rights and liabilities. They remain operative even after constitution as against non-citizens. The said observation could not obviously apply to post-constitutional laws. Even so, it is said that by parity of reasoning, the post-constitutional laws are also void to the extent of repugnancy, and therefore the law in respect of non-citizens will be on the statute book, and by the application of doctrine of eclipse, the same result would flow in its case also. There is some plausibility in this argument, but it ignores one vital principle: the existence of or the non-existence of legislative power or competency at the time when the law is made governs the situation. Chief Justice Das dissented. He was of the view that post-constitutional law may infringe either a fundamental right conferred on citizens or a fundamental right conferred on any person, citizen, non-citizen, and that in the first case, the law will not stand in the way of exercise by the citizens of that fundamental right, and therefore will not have any operation in the right of citizens, but it will be quite effective as regards non-citizens. Then they discuss Jaini's case. Kindly come to para 36. If the meaning of the word void in Article 13.1 is same as its meaning in 13.2, it is difficult to understand why a pre-constitutional law which takes away or abridges the rights under Article 19 should remain operative even after the Constitution came into force as regards non-citizens, and a post-constitutional law which takes away or abridges them should not be operative as respects non-citizens. The fact that pre-constitutional law was valid when enacted can afford no reason why it should remain operative as it respects non-citizens after the Constitution came into force, as it became void on account of its inconsistency with provisions of Part 3. Therefore, the real reason why it remains operative as against non-citizen is that it is void only to the extent of its inconsistency with the rights conferred under Article 19, and that its voidness is therefore confined to citizens. Ex hypothesized, the law became inconsistent with their fundamental rights alone. If that be so, we see no reason why a post-constitutional law which takes away or abridges the rights conferred by Article 19 should not be operative in regard to non-citizens, as it is void only to the extent of the contravention of the rights conferred on citizens, namely those under Article 19. So this is the divergence which emerges, but only in the context of Article 19, because Article 19 is limited to citizens. Other fundamental rights are not so limited. If, however, the court finds that any other fundamental right is limited, but this is we find there are two constitutional benches of equal strength. So this obviously cannot amount to overruling of the earlier dictum in Deepchand and Jaini, but there is a divergence. All three of them being constitutional benches of same strength. Now, this was sought to be supported.
Can you formulate the divergence that Ambika
The
Mills?
divergence between Ambika Mills on the one hand and Mahendra Lal Jaini and Deep Chand is that both are dealing with a situation in 19, unlike Sundara Ramaiah. But they are saying that one says that this proposition that a law which is violative of 13(1) continues to apply for the past transaction as well as for a non-citizen. Whereas this defect is noted by Justice Matthew in Ambika Mills that if this is the position with regard to the second aspect of non-citizens under 13(1), then the position will remain same under 13(2) also because Quay 19.
Quay 19.
Now, my learned friends want to enlarge this and apply it to 368. If it cannot apply, be translated and applied to legislative incompetence, it cannot be. So the soil is completely different. Before one applies a law declared in respect in one context, one has to note what were the limitations of Article 19, what is the structure of Article 19, what is the structure of other fundamental rights, and how it is different from incompetence cases. Incompetence means you don't have that power. Now, to support this migration of the legal dictum in the field of 13(1) and applying it to 368, they sought assistance from the observations of the great jurist Shri H.M. Sirvai. Unfortunately, my learned friend quoted only proposition 4. Would have been more appropriate if entire para 8.30, which I have extracted at page 25 of my written note, to end. Page 25. So what Mr. Sirvai does is that he discusses first Keshav Madhav Menon, Peshi Kaka, and Sundara Ramaiah cases, and then draws what are the propositions flowing from them, which is extracted in 8.30, para 27 of my note. The extract from I should have been Shri, H.M. Sirvai, Constitutional Law of India, 4th edition, volume 1, page 4156, is actually proposition 4 stated in para 8.30, which is reproduced. There is a distinction between a law unconstitutional for lack of legislative power and a law unconstitutional because of violative of provisions of the Constitution other than those which relate to the distribution of legislative power. A law which is unconstitutional for lack of legislative competence is void ab initio. A law which is unconstitutional for violation of constitutional limitation is unenforceable so long as it continues to violate constitutional limitation. Such a law, whether pre-constitution or post-constitution, is not wholly void if it violates fundamental rights. It is merely eclipsed by the fundamental right and remains, as it were, in a moribund condition as long as the shadow of the fundamental rights falls upon it. When that shadow is removed, the law begins to operate proprio vigere from the date of such removal unless it is retrospective. 3. A law void for lack of legislative competence is not revived if legislative power is subsequently given to the legislature which enacted it. A law partly void because of violation of constitutional limitation operates proprio vigere when limitations are removed. 4. When a court declares a law to be unconstitutional, that declaration does not repeal or amend the law. For to repeal or amend the law is a legislative and not a judicial function. This is what my learned friend wrote extracted in his written note. The word void in 13.1, 13.2 does not mean repealed, nor is the law declared void under 13.1 or 2 obliterated from statute book. Such a law is not wholly void, but by express terms of the article is void only to the extent of its repugnancy to or contravention of the provision of Part 3 relating to fundamental rights. The above conclusions were drawn by Shri Sirvai after discussing the cases of Keshav Madhav Menon, Peshi Kaka, Hikaji Dhakras, and MP Sundararamayya. Shri Sirvai proceeds to then consider the subsequent cases in Baseshwar Nath, Deep Chand, and Mahinder Lal Jaini and Ambika Mills. Based on the discussion, he called out the following propositions. That is 8.37. Justice Matthew, all this your lordships have seen, your lordship comes to see. In fact, I may read A also at page 27. If, as held in Mahinder Jaini's case, the word void in Article 13.1.2 had the same meaning, it was difficult to understand why a pre-constitution law violating Article 19 should remain operative against non-citizens after the commencement of the Constitution, and a similar post-constitution law should not remain operative against non-citizens. The fact that the pre-constitution law was valid when enacted was irrelevant in its continuing to operate against non-citizens, notwithstanding the provision of Article 13.1 of the Constitution came into force. The real reason why the law remained operative was that only the law became void under 13.1, which took away or abridged the fundamental rights in the Part 3, and since Article 19.1 does not confer any fundamental rights on non-citizens, such a law remained operative against non-citizens. If so, a similar post-constitutional law would also remain operative against non-citizens. Rights do not exist in vacuum, they must inhere in some person, natural or juridical, and under Part 3, they inhere even in fluctuating bodies like religious denominations. C. The scheme underlying 13.1 and 13.2 is the same. Article 13.1 makes a pre-constitutional law to the extent of its inconsistency with fundamental rights. Article 13.2 makes a post-constitutional law void to the extent of its contravention of fundamental rights. In both cases, the law remains operative with non-citizens because Article 19 does not confer any fundamental rights on non-citizens. The voidness is not in them, but to the extent only of inconsistency or contravention. Therefore, void in Article 13.2 can only mean void as against persons whose fundamental rights are taken away or abridged by law. The law might be stillborn so far as the person, entities, or denominations, those fundamental rights are taken away or abridged, but there is no reason why this law should be void or stillborn as against those who have no such rights. So even according to the learned author, in part it is stillborn, which is a theory which your lordship will have to test in some case. In this case, doesn't require your lordships to go into all this. But since my learned friends have raised it, therefore only I am trying to demonstrate that these dictums and the debate is in the context of breach of Article 19 and in the context of a debate of citizen versus non-citizen.
Yeah.
So in some appropriate case, your lordship may go into all this, but in the present case, it's a case of incompetence, constituent incompetence, which may be considered to be akin to legislative incompetence, where all these cases, including the learned author, are at one, that in this case of incompetence, it is null and void, ab initio, beginning, as if it was not there at all, as if it had no effect. And in case of 368, it will be a case where the Constitution does not stand amended on account of Section 4.
Article 368(4) also was struck down because judicial review of the 42nd Amendment also was barred.
That's right.
That was also struck down
That's
in Minerva Mills.
yes.
Section 55.
Then they brought in Lord separation of powers. And it is well settled, Lord. I will not trouble your lordship. So it's page 30 and 31. I have mentioned 3 cases. Your lordships have said that under the Constitution of India, there is no rigid separation of powers. Even this court makes rules of court, rules regarding to servants, etc. So there are some legislative functions. Then there is, as I said, the court makes judicially also makes law. Not in the way the Parliament does, but through interpretation and declarations. Under 141.
Most of the
So
rules,
overlapping of functions.
Yes,
civil servants make most of the rules.
that's right. Most of the rules are made by them. So there's no rigid separation. Even in the matter of judiciary, notwithstanding that the fact that it is a basic feature of the Constitution, still the salaries are fixed by Parliament. There's so many things which Parliament does with regard to the courts and judiciary. The legislatures do. So, so the separation of power doesn't really, the fact, court doesn't need to repeal. So I will just draw your lordship, finally coming back, your lordship, just note at page 11, I go back, starting from Keshavanand, I go back to Keshavanand, Bharti, and I place the 10 judges order which was finally passed in that case. I have extracted at page 11. And the direction number 2. Now kindly correlate this para 75, Chief Justice Y.V. Chandrachud uses the same expression, does not enable Parliament. So the ability of Parliament to introduce a bill is not there. The ability of Parliament to pass that bill is not there. Such a bill, therefore, itself, Section 4 being part of the bill, goes out. That ability is lacking. Now, this is something not there in 13.1, 13.2, so your lordship need not enter into that debate. And the next page I have quoted from the IR Polo's observation. The bold portions in 124 and 125. It would fall, last 4 lines of the bold portion in 125 would fall beyond the constituent power. And then at page 14 is para 75 of Minerva Mill, identical expression. Section 4 is beyond the amending power. Therefore void. So I'll just wind up, Lord, with giving to your lordships the 4 cases which I've listed out, Lord, on the proper first part of it. On that first one, the first 2 cases are on material resources. That is 1992 Supplementary 1 SCC 692, Assam Sillimanite. Volume 5, page 2640 at 2654.
654.
Yes, ma'am. And the second is Jelu Bhai versus State of Gujarat, 1995, Supplementary 1 SCC, 596, Volume 5, page 2676 at page 2700, para 29. The first one is para 34. They've said that material resource has to be construed widely. The third case is Jagannath versus authorized officer, that's 1971 2 SCC 893. 893, para 18 and 29,
Volumes?
which is volume 2 annexure 7, volume 2N annexure 7,
Page?
at page 184, 198. This is with regard to acquisition, which I said, Lord, it's part of the 39B. So this case directly holds that acquisition and distribution go together under 39B. And the last is, Lord, Pathuma's case 1978 2 SCC 1. Para 5 and 8, volume 2N, annexure 18. That's page 891 at 898 to 900. This is a case of that agricultural credit loans, agricultural debt, which was wiped out and upheld by a 7 judges bench of this court. So even that is a material resource upheld with reference to 39B. Yes,
Yes.
the Land Solicitor General has mentioned this case. I'm grateful.
Thank you, Mr. Bedi. Thank you.
I did not, my lord, assist. I'll take 5 minutes on that.
Yes.
Bro, please come to my submissions 2L, page 23. Just, my lord, I am highlighting. Because I see some, my lord, problem, just I am a word of, my lord, caution. My lord, the lordships are aware, as, my lord, the 42, my lord, 2L, L for Lakshadweep, no 42. The lordships would be going into it. I'm just bringing to your lordship's notice without reading it that this is also one more angle.
2L.
2L, L.
There's no page 42 actually. There's no page.
223.
23.
Para 24, 42.
Yes.
Para 40. But sum and substance of the argument, which I, my lord, fully support and adopt, is that if there is a legislative incompetence declared by the court, then it goes, if it is held to be unconstitutional on the ground of violation of fundamental rights, it remains as a dead letter, my lord, according to them. But now there is one nuance which is not concerned, we are not concerned, but in some other matter, my lord, it might affect. One provision was declared unconstitutional under 14 and 19. It remained on the statute book. Therefore, my lord, the Parliament removed that unconstitutionality which was based on 14 and 19, and that act is upheld by this honorable court. You must kindly bear one fact in mind. So, page 23, your lordship would find all this judgment. Lord, I am not going. Keshav Rao, Madhav Menon, Peshi Kaka, etc., etc., etc. But, my lord, Blackstone doctrine, my lord, I would, in just 3 minutes, my lord, I'll be able to, my lord, satisfy your lordships. And this is accepted with some addition by Indian jurisprudence. But since your lordships would be writing on this, it may not be, it should be complete. That's the purpose. But Blackstone doctrine, my lords are aware, says that if your lordship declares a law invalid on the ground of incompetence, constituent incompetence or legislative incompetence, it relates back to the date on which it was passed, and your lordship's declaration of unconstitutionality would mean it never existed. So that is the doctrine of, that is Blackstone doctrine. For the first time, it came to be considered by Indian court in Golaknath case. Lord, your lordships would find that, I'm not reading, my lord, but at para 47, page 25, Golaknath. Lord, Golaknath case, the lordships accepted Blackstone doctrine with one exception. Since your lordships have the power under 142, your lordships decided that when we declare the law to be invalid, it would go to the root. It never existed. However, we have the power of prospective overruling. So if we say that it would be overruled from today onwards, then it would not relate back. But we are not concerned with that situation. But leave that, Lord. I am not reading the Golaknath case. Please come to, my lord, page 27, para 51. I am just giving the citations. Lord, that is Jarnail Singh versus Lakshmi Narayan, where, my lord, this Blackstone doctrine. Lord, why I am saying this? When section 4 of the Amendment Act is declared unconstitutional, it goes to the date on which it was made and it never existed. That is Blackstone doctrine. So whatever was there earlier remains. It's not revival. The section 4 never existed. Lord, then your lordships would have para 52, CIT versus Saurashtra Kutch Stock Exchange Limited, 53, PV George versus State of Kerala, 54, Chandrasekhaya versus Jankiri. Then, my lord, M.A. Murthy, this is, my lord, a lead judgment on the point. Your lordships can, my lord, at your lordship's leisure, go through it, para 55. Now, my lord, come to page 30, para 56. Other jurisdictions have also accepted this doctrine. And that's what, Lord, I wanted your lordships to, Lord, take note of, so that when, if your lordship decides this question, it should be, our assistance should be complete. Therefore, Lord, that other jurisdictions also follow the same doctrine. I'm not reading, Lord. Harper versus Virginia Department of Taxation.
Look at them, Mr.
Lord, this is a US. Lord, thereafter, next is Supreme Court of South Africa, para 57. Democratic Alliance versus Minister of Home Affairs, Lord, Supreme Court of Appeal of South Africa. Then, my lord, Irish Supreme Court, my lord, para 58. Then, Lord, Australian High Court of Australia, that's the highest court, Lord, 59. Then 60, Supreme Court of Canada in so-and-so versus so-and-so. I have quoted, my lord, the relevant part. And, Lord, thereafter, again, my lord, some judgments of our court, my lords. So my respectful submission, my lord, in cases where there is unconstitutionality declaration based on fundamental rights. It remains, but it can be cured by the Parliament. But if it is either lack of legislative competence or constituent competence, like in the present case, it goes, and in any case, alternatively, as per Blackstone doctrine, it never existed the moment Minerva judgment is delivered. So these are my submissions. But as my lord, I have assured your lordships yesterday, I have put one pager, but as page 2U, volume 2U. It's one page. It's just been mailed. I'm not reading it. What is, my lord, my interpretation of Article 39B? I have already, my lord, made my submissions on that. But yesterday, my lord, I sought your lordship's permission to place that one pager. It is literally a one pager. I'm grateful.
Yes, Mr. Shankana.
Okay, so.
Before I address you on the points which I had put in my notes and I'd highlighted yesterday, I thought I'll just respond to a few things that took place this morning. First is with reference to Mr. Dwivedi's arguments on the higher standard. I adopt what he says about constitutional or constituent incompetence. But I'd go a step further and say that as far as the basic structure doctrine is concerned, that is the very ethos of the Constitution. That's the fundamental, the Grundnorm, as it were. I don't think there is the possibility of, in any way, limiting a violation to it. If we accept that a breach of the basic features have taken place, that cannot be tolerated by this court or by this country even for a minute. What I mean is that if therefore this court declares at any point of time that the basic structure has been violated, we cannot possibly consider a situation where that basic structure violation is permitted to have continued even for a short while. It means at its fundament that constitutional balance has been upset. So restoration to its very essence, to its very genesis, is a constitutional imperative. It is a mandate. I pitch it a little higher than what Mr. Dwivedi did, because a question of legislative incompetence may permit this court, particularly with its powers under 32 and 142, to at some point carve out remedies which may permit even a legislatively incompetent law to a certain extent to be saved for whatever purpose. But not so with the violation of the basic structure. Because if it's a basic structure violation, everything has to go, in my view. It's absolutely fundamental. Linked to this is the fact that this prospective overruling doctrine, which Chief Justice Subbarao heavily relied upon in Goloknath, was a pre-basic structure situation. So there he did not have the advantage, though the arguments were made by Mr. Nambiar about implied limitations on the constituent power, which was not accepted. But subsequently, when Mr. Palkiwala argued it before the case on the bench, it succeeded. So prospective overruling, whether it is available to a constitutional amendment challenge after the basic structure doctrine, is not a question that's ever been explored. But I would say it is not available. It is not available for a constituent court to say that, yes, our basic structure has been violated, but today when I am saying that that violation has taken place, I am going to save everything that took place from then till now, but not going forward.
So it goes to the root of the matter.
Absolutely goes to the root of the matter. Which is why, if you step back a bit, the way 31C stands today is that 39B and C doesn't upset the balance. But the minute on this side, apart from 39B and C, you put A, D, E, and then you put 38, 37, 30, 40, 41, etc., the balance goes. That's why Minerva Mills said, no, we can't send it that far. But maybe those two. But between those two subclauses of 39 and the entirety of Part 4, Where does that balance stand? We don't know, it's not been explored. But it is because that balance gets completely upset that the basic structure is affected, which is why I would say there is no question. It goes absolutely to the root of it and it cannot be permitted even for a moment. The second, I think, just to assist, because your lordships had put a question, is there an instance where a provision has been struck down and then the legislature has taken steps? It's happened at least once to our knowledge, which is in Indira Gandhi versus Raj Narayan, 329A was struck down, where they said the election of the Prime Minister cannot be questioned. But that was in 1975, in November 1975. But in 1979, the 44th Amendment omitted that provision completely. So that has happened at least once. I'm sure there might have been instances where it has come up again. And then I'm very grateful to Justice Bindal for highlighting the oversight which is entirely mine. The provisions which have in fact been struck down by the Constitution, at least in this version, we have put them all in italics, which includes the NJSC provisions. Part 9B, cooperative societies, because 368(2) proviso was not met. Everything there went except dealing with multi-state cooperative society or a competence issue. So we very carefully went through it and put it in italics. But your lordships are right. We omitted to do that with the Chandra Kumar provision. That's a correction that we need to do.
Not in your book only, it is there in the government publication.
No, that is there. It's there across publications. But I'm saying here at least,
Question was how to sort it out.
No, absolutely.
They are bound to do it, as you said,
No,
29
because
they deleted.
eventually, my lords, all authorities will say ignorance of the law is no excuse when it comes to a citizen. So the citizen has to know. Exactly. There has to be some possible, maybe some PIL will be brought before the court at some point.
Deem in this case, everybody is raising this.
Yes. Correct.
So if this solution is given immediately after the judgment, the deeming arguments are not required.
I would just say, suppose there was a review petition or a curative, and then that judgment was overturned. The poor draftsman will be going erasing and putting it back, erasing.
Not that immediately next day they have to take it.
No, I know, I agree. Or there may be an overruling at a later
Yes,
stage after.
a larger bench may say
Yes,
that the striking down was bad.
correct.
Therefore, it gets revived by a judicial verdict.
I think the discipline that the publishers follow effectively is that, look, if the legislature has done something, we leave it there. The courts have taken a decision, so we'll have to put a footnote or something.
Brother Bindal, not the Gopal Shankaranan, the senior counsel, but Gopal Shankaranan, the editor of the Constitution.
No, but we will carry out that correction. Well, with reference to, I think, a very interesting remark that came from my Lord the Chief Justice, that what would happen if instead of saying part 4, each of the provisions were mentioned. That was in fact done. There were 2 amendments moved in the 44th Amendment before Minora Mills, but 2 private members had moved amendments suggesting not the entirety of part 4, but 37, 38, 39, and they mentioned 4 or 5 others. Now, it's very interesting because if that had come up and your lordships had struck that down, then perhaps I think it would be very valid to say that the provision has no meaning thereafter. Because you've listed 39 among those.
There you are right, completely.
But that's not what happened. And there they didn't even place those amendments finally for voting.
But they would have probably struck down everything but 39B and C.
Perhaps,
Because they were bound by Keshwanand.
it would
Perhaps
remain.
They may have.
39B and C would have been,
Correct.
would have
In
remained.
which case it would have been much
It was bound by the 13 judge judgment.
And
Yes.
doctrine of severability would have applied. They
correct.
would have saved that.
Correct, it would have saved that. First, now I'll just quickly go through 2 notes. I'm just telling you what my points are first. The 2 notes are 2E, E for extreme, not elephant, extreme, and then 2M, M for middle. So that's what the court is being called upon. 2E and 2M.
So you want us to accept 2M and discard 2E, or what is?
In a sense, so that we can have a balancing one. So I'll just explain what those 11 points are so that your lordships knows immediately what the sense of it. The first is with regard to the background of 31C. I think it's integral for us to understand the historical background as well. Nobody explains this better than Granville Austin in Working a Democratic Constitution. Chapter 10, I think a very interesting reading about how these 3 constitutional amendments came together. 24, 25, 26, and what the aims were there. Interestingly, this 25th Amendment was part of a set of amendments to get around R.C. Cooper, where 10:1, the nationalization of the banks had been rejected. Now, why this is interesting is, apart from bringing in 31(2) by Section 2 of the 25th Amendment, it brought in 31(c) by Section 3 of the 31st Amendment, of the 25th Amendment. Now, all of these were subject matter of Keshananda eventually. But what is interesting is the three things that took place. The first is that on 10th Feb 1970 is when the judgment in Cooper takes place. On the 28th of October 1971, the Law Commission goes into the draft Constitution 25th Amendment Bill to understand exactly how much of it would be approved, would be worth it, etc., etc. The members of that commission are very interesting. It was chaired by former Chief Justice Gajendra Gadkar, but I was mentioning that this 46th report of the Law Commission,
Yes.
the Law Commission consisted of Justice Gajendra Gadkar, Mr. P.K. Tripathi, Mr. P.M. Bakshi, and the former Law Minister and Home Minister from Kerala, who was sitting judge of the Kerala High Court, Mr. V.R. Krishnaiyer, at that point of time. The report goes through at some length with the bill, the 25th Amendment bill, makes several observations on it, which I don't think leaves any doubt about what it was dealing with. It was very clearly dealing with private property, because in Cooper, they were dealing with the private rights of shareholders and of banks. And it was to get around that, and they take note of it. I have annexed it as Annexure 1 to this note, to the first note, which is 2E. Annexure to it, your Lordship, if you have it open, you just have to tap on it, it will take you to Annexure 1. Now, they also said that the implementation of the directive principles through the fundamental right route or its limitation was marking a new era in constitutional history. So the Law Commission strongly approved this kind of amendment coming in. They, however, did not approve of the latter part, which excluded judicial review, which is exactly what Keshananda did later. Now, when this came up for debate in Parliament and the bill was piloted through by the Law Minister then, Mr. Gokhale, he said, and I just quote, "The individual's right to private property must yield second place to the supervening right of society to acquire property for a public purpose." Yet again, emphasizing that it was dealing with private property. There wasn't a doubt about it. They didn't categorize how much of private property, what kind of private property, but clearly dealing with private property. This is extracted uniquely by Justice Krishna himself in Ranganath Reddy at para 73. He quotes both the Law Commission report, of which he was a part, as well as the minister's speech. Now, this is point 1. I suggest your Lordship just sees the speech, the Law Commission's report, which exhaustively deals with the origins, point 1. Point 2. When one looks at Article 31C, I think it should be seen as part of a scheme, because the title of that part of Part 3, Saving of Laws, came much later, only with the 44th Amendment. But 31C is part of a scheme, and this many cases have said, which includes 31A, 31B, 31C, and 31D, which doesn't exist any longer, which was dealing with anti-national laws. But 31A, B, and C, all of them, do two things. One, they definitely deal with private holdings, private property, private management of companies. 31A deals with that while amalgamating companies, etc. It permits private control to be taken over. 31B does the same. When many of these acts were put in the 9th schedule, most of the initial ones were all dealing with land reforms. But the later ones, like maintenance of internal security, reservations in Tamil Nadu, which has gone up above 50%, etc., haven't just been limited to that. But they have been done to insulate from a challenge which can arising out of Part 3. In which 31A and 31C make specific reference, as initially drafted, to Articles 14, 19, and 31. 31B doesn't. 31B insulates the entirety of Part 3. Says Part 3 cannot be used at all. That's what Coelho clarified. That look, if it's a basic structure impact that's had, and 14, 19, and 21 together seem to suggest that can definitely be used to challenge any of those legislations. So if you see 31A, B, and C together, it is together dealing not only with public or government, etc. In fact, perhaps it's not dealing with public and government at all. It's only really dealing with private holders. And from that arises a further point that why would you insulate from Article 19 unless there were citizens who had private rights under 19 which had to be agitated? Because if you were not touching private rights, there would be no need for an Article 19 agitation at all. Which is in fact, if you see the Law Commission's report again, they make a suggestion saying why the entirety of 19(1)A to 19(1)G. When you want to insulate 14 and insulate 19(1)F and G. Only property and your right to trade and profession. Why A, B, C, D, free movement, free speech? Why should that come in? But then they also question themselves by using Sakal papers, etc., and say maybe free speech, maybe a printing press, for example, maybe that needs to be covered. So I'm just pointing out that Article 19's insulation suggests very clearly that it's dealing with private rights. Now, I have, if your lordships wouldn't mind, just in that note, which is 2E, yes. If your lordships can come to the page 2, I have put a chart which is somewhat similar to the chart your lordships saw. This is a page 18, it's annexure 2 to this note, page 18 of 2E. It's similar to the note that the chart that the learned solicitor had shown your lordships, but it's different to this effect that I have put the highlighted portions to show the journey of 31C from then till now. The present form, which is the last column, is our suggestion of how it stands as of today. Without any
That's the matter for adjudication as to whether the words, the principle specified in clause B or C of 39 get restored. In that case.
Whether it gets restored. This is our suggestion, present form. We believe that this is how it stands. But I put notes at the bottom so your lordships can see at the bottom of the second, fourth, and fifth columns to show what actually took place. And this is how it has moved. Now, I'll just first deal with 31C points now, and then come to the 31E points. As far as 31C is concerned, Manoj, the first proposition I have is that this has been dealt with at length by Mr. Dwivedi, so I'm not going to re-agitate it or say anything about it. Just that the question of revival would only arise if there was a death. There has, in fact, been no death. The fact that it was only section 4, I don't think there is a doubt about it. And if your lordships comes to 2M, which is the other note, there is an annexure to it, which is annexure 5. The lordships have note 2M. The second note came after the submissions that they had made on 31C. So 2M. I'm sorry?
Page number.
It's the second page of the note. 2M, it's the second page. It will start with Roman 5. The first 4 are in 2E, then 5 onwards are here. Yes, sir. Which starts with Roman 5.
2M, you said.
2M, M.
M.
I'll Instead of taking your lordships to and fro between these notes, I thought I'll just finish with note 2E to start with. So it'll just be simpler. Note 2E, page 3 is where I'm at. This note will end on this page. Page 3, note 2E. I mean, it's item 2E. All my lords have that. These are the points regarding the interpretation of 39B, my lords. And if your lordships can see the third bullet point, the words material and resources are interpreted by dictionaries in a very wide sense. This is also the interpretation offered by the concurring judgment in Raghunath Reddy. The consistent interpretation of 39B has been in favor of private property being included. The list of 16 judgments which interpret 39B, which we have put in this annexure 4. So which are dealt with in Article 31C. So I think Mr. Srinivas Murthy, when he was arguing for the petitioners, had made an allusion to 39C. If your lordships were to take Article 39 for a minute, if I can trouble your lordships, it starts with, and I think those words are important, at the beginning of Article 39. The state shall, in particular, direct its policy towards securing. And it's a continuation after securing, which is A, B, C, D, E, F. So A, D, E, and F are dealing with women, children, and equality generally. P and C fall together. C, which is the other provision, is that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. I would argue that this possibly could not mean concentration of wealth in public hands, in that of governments and corporations. It would possibly mean, and I think that was the intention, that it would be the concentration of wealth in a few hands, so that they take away all the means of production, etc. Now, if that is what it is, and if you were to read, because C is in negative terms, so that it would not result in concentration of wealth. P is in positive terms, where it says that the ownership and control of material resources of the community are so distributed as best to subserve the common good.
What is meant by resources? It doesn't say property, right? It refers to resources.
Now, there are these 16 judgments of the passages put out. All of them are constitution benches. All of them have consistently seemed to hold that resources are private resources as well. So my suggestion to this court is that the question that's referred is not about what is the scope of resources. The question is only whether public versus private. That's the only question. Now, if your lordships were to answer positively saying that it includes private, I think that question is best answered as it is and left to be interpreted by later courts when a particular situation comes up.
But if we say all private resources, all private property is comprised in resources.
Yes.
There's nothing left for a future bench.
I'll give your lordships the reason why. Because in 2019, in February 2019, a manufacturer of vaccines sets up a company and he starts manufacturing vaccines. At that point of time, it's an entirely private resource and he's running it perfectly as his domain. But come March 2020, and we have COVID hitting the world, at which point that resource, which is an entirely private resource, pretty much untouched, becomes something which is essential for the entire community. And then the state has to step in.
That private property was outside the scope of 39B.
That's all.
But we are saying that well, there must be some parameters laid down.
Yes.
Otherwise, the logic of Ranganath Reddy and Sanjeev Kok is an individual is a part of the community. Therefore, the individual is a part of the community. Since the individual is a part of the community, everything that is owned by an individual is community ownership.
So
this is like a hark back to Ayn Rand's, Atlas Shrugged and all that line of Fountainhead.
No, that's true. That's well. The reason why I would refrain from making any suggestions about what the scope of resources is only because of this. Very honestly, much like the founding fathers were, they had the wisdom of a future day in their minds when they made these provisions. I think if we were to take the thought forward, if today we were attempting to lay down strict definitions, it could come back and boomerang on us on a future date. If 30 years down the line, one interprets a judgment which is rendered today, which says, for example, that anything within the house which is meant for the personal use of individuals within the home would be excluded from this scope. And if, say, in 5 years' time, we are in Bangalore and there's no water in the lakes and there's no water anywhere, but I have a tank or I have a borewell in my house, and the state needs to commandeer that so that the water is then shared with everybody. They will use this 9-judge judgment and say, I'm sorry, this stops you from coming further.
No, it doesn't. It doesn't. It only makes sure that you don't have the immunity. That's all.
No, but the question
You can
is-
still justify a law. You
Correct.
can still justify a law for acquisitioning private resources on the ground that it's in the public interest.
Correct, but because of the,
Immunity is not available. That's all.
but the lordships are very familiar with the fact that if somebody were to file a writ here, they'll be told to go to the High Court. They will go to the High Court. Meanwhile, people are dying of thirst, and they will file a petition there, and they will be told a 9-judge Supreme Court judgment holds the field, and that poor judge will have his hands shackled, so he will have to decide in favor of the petitioner. I'm saying today, I'm just off the cuff, this is an imagination of mine, and my imagination is not stretched far enough to think of all possible resources which could or could not, in the age of AI, in the age of cryptocurrency. My friend Nipun Saxena wants to address your lordships on that, on the fact that property can have so many different and resources, because I think there is a distinction between property and resources. I think we will fairly admit. So resources means there is some utility coming from that property, which is going to be employed for a particular purpose.
Don't confine the.
Correct. My suggestion is, since the question is only, can you enter the private domain? The answer should be yes, you can. To what degree, what can be touched? I think best left to smaller benches to decide when that question arises. Because
Yes,
make a,
now we have-
yes,
Can I ask something?
Yeah, yeah.
sorry. Yes,
Sorry.
sorry.
Please, sir.
Yes,
Example that you gave of
Yes.
somebody having the right to manufacture vaccine.
yes.
See, that would definitely be part of what we understand as material resource.
Yes, it would.
And can we not think, taking a cue from what fell from this Chief Justice on
Yes.
literature,
Yes.
may I describe you as Mr. Howard Roark and say that you are visualizing a world where, under the provisions, the material resources can certainly be utilized for a situation of the kind that you have visualized.
No, I agree, Manoj, but the difficulty I find myself in is one of syntax. When we use the phrase material resources, are we saying that any particular resource so identified is a material resource for all time to come? Or, because in English, the word material has two definitions. One is tangible versus intangible. That is one definition of material.
Value.
The other is value. So,
Of utility and value.
or utility or value. That's the other definition. Now, if I'm using that definition, something which may not have been a material resource yesterday may be in a critical situation a material resource today. The question is, how do we define on a particular date what is that material resource? Because these are, your lordships.
Today and tomorrow,
Yes,
to answer to that, material resources to subserve the common good.
correct.
Today it is not, it is a material resource, but it is not to subserve the common good because
Yes.
everybody has water.
Yes,
But today I am the only one who is having the borewell with water.
correct.
So now today material resource becomes to subserve the common
Lordships
good.
are right. Your lordships are right. Definitely. Because the only question that I have in my mind is that when we start looking at resources, is there a possibility there are resources which may not be treated as material resources today? Meaning the source value definition. Not having that today, but it may have it at a particular day, or vice versa. But the question is, do we have to go down that path for the purposes of this reference? This reference really calls for only do you enter the domain or do you not? If you do enter the domain, then the state has to justify in a given case.
You tell a manufacturer of semiconductor chips
Yes,
situated somewhere in Taiwan
yes.
that, well, you manufacture semiconductor chips in India because India needs semiconductor chips. But sorry, this is a material resource of the community. We might just take it away.
We
It's gonna
have
say,
possibly
sorry,
been-
I don't want to invest in your country. This is the level of protection which you give me.
I agree. Your lordship and I have perhaps been reading the same book if it's chip wars. So it's, no, I fully agree. So the question is, I'm sure democratic decisions will be taken by legislatures and governments about going that far. The only question is, do we have a deficit of faith in that system that everything needs to be laid out and defined in a very, very stark fashion today? I feel for the purposes of the questions that are referred, it's a limited question that is being referred because a question has been raised saying, can you go private? Really, for the purpose of this case, I don't think anybody is doubting that ownership of physical property, land, tenancy, etc., would be beyond that. If they do, they will raise that questions before a bench. Once it's answered here.
The sister wants to.
Yes.
Wanted to say, see, it is not just material resources per se.
Yes.
It is material resources of the community.
Yes.
And it is for the purpose of distribution.
Correct.
Now, if you read this in the context of clause C,
Yes.
where it speaks about the operation of economic system,
Yes.
distribution is an aspect of the economic system.
Yes.
So it
Absolutely.
should be read in that context.
I fully agree.
So that the material resources of the community is
Yes.
so distributed,
Yes.
so that ultimately the operation of the economic system does not result in the concentration of wealth and
Absolutely.
means of production to the common detriment.
I
So
endorse.
both these have to be read.
I endorse it fully.
So
Yes.
question is, if a person invests,
Yes.
puts up a huge factory,
Yes.
starts production,
Yes.
tomorrow it cannot be said that it is going to be taken away for the purpose of distribution to the workers.
No, my lord,
That is not the aim of that, be as such.
perhaps it's not, and your lordships will decide so in a particular case.
It cannot be, you see, only private resources also to be included also. It may not be.
No, the question only, in my view,
A private resource is
Yes.
not a material resource of the community. Then the right to property, various other rights vis-a-vis real property.
yes.
What happens to those rights under the common law and the statutory law?
So I'm glad your ladyship referred to that. The reason why these phrases are used, and I've mentioned that in my other note, is that all these phrases come from Roman law. And that's the origins behind how the founding fathers inserted these provisions in. They also have been borrowed from the Irish Constitution. But in Roman law, when they talk about ownership, and I've given a chart showing the different types of ownership, there's the type of ownership of property which can be taken, which can be distributed, and which can be utilized. And there's the type of ownership that you can't, for example. They refer to it as res nullius. Wild animals, for example. Nobody has ownership over those. Forests, waterways, those kind of things. Nobody has ownership over it. The state doesn't own it. Nobody owns it. It is available for everybody. And the state in public trust holds it. So I think the only question, the way I would convert that question is to say that if the state is being told today that you cannot employ 31C for any property that does not belong to the state, then I think that is a very extreme view. The minute we are permitted to embark into private ownership of any sort, it may be a company, it may be land, it may be cars, it may be trucks, it may be any one of these things. For example, any natural disaster takes place and we need to requisition something, whatever it could be. It could be medicines, it could be food, it could be any one of those things. Food, for example, one could claim it's for personal use. I need it, but we have starving infants, perhaps, fatherless babies who are left after a flood. We need to take care of them. Surely these powers can be employed for those purposes. It's a little difficult now to stand and determine all of those. I'm saying that if you can go into the private sphere, that's all. That's where the question stops. If you can go into the private sphere, where we can go, in what circumstances, because Article 21 survives. Article 21 is available for that challenge.
But the only problem
Yes.
is that you can't go as far as Ranganath Reddy, which says an individual is a part of the community. That everything of an individual is that of the community.
Perhaps not. Perhaps not.
That may
That's
be a
true.
little
That's-
far-fetched.
and like Mr. Dwivedi
There may
said,
be certain vital aspects of a resource of an individual
Correct.
in which the community has an interest as well.
correct.
Which is a resource of the community.
I think that I think would
Data,
be fair.
data or,
Absolutely.
or the airways, spectrum.
Correct. All of those. There are many examples. I'm sorry.
Etc.
Yes.
Prior to distribution
Yes.
is always under the particular Land Acquisition
Land-
Act or
yes.
whatever,
Yes.
or a Nationalization
Correct.
Act.
All of those are available.
Yes.
Yes. But
And it is after giving a compensation, fair compensation.
correct. No, if your lordships consider intangibles, for example, intellectual property,
Yes.
both the Patents Act and the Copyright Act has compulsory licensing provisions, 84 and I think 31 of. Now, compulsory licensing provisions permits the state to step in and take what is your intellectual property and employ it. Take it as a compulsory license and ensure that it is employed for a larger purpose. There was a discussion, I think, yesterday about cancer cures. Anything of that sort, for example, which could be utilized. Now, there surely it can't be said, 14 or 19 because both apply. Can be used when you have a provision like this, which could be utilized by the state. Because otherwise, they could become vulnerable to challenges under 14 and 19. Those are provisions, for example, which we could defend on that anvil. Well,
Community first.
it's arguable. I think it'll depend.
Which one can?
I think it's arguable, but I'm very honestly, I'm not addressing your lordships on community and its scope. I don't want to take too much time on addressing that. I haven't gone into that in detail, but I feel it's best left on to a given date. Now, if your lordships can then, just for 1 minute, in the middle of this note, I'm done with this note, middle of this note, Annexure 4, if your lordship sees, I have listed out the judgments.
Forms, etc. This court struck.
If your lordship were to come to page 38, my lords. Page 38, just one para of Bhim Singh Ji, para 16A, 16 capital A. It gives a flavor of what could possibly go into this. About 10 lines down, your lordship sees the wide definition of industry. So it's underlined, the underlined portion. Page 38. Bottom, it's underlined in red. Let's have it. It says, Justice Mishra?
Begins with certain basic facts. I mean, the paragraph begins with that.
Yes, just about 8 lines down, you
Yes,
find the
that's
part.
the
which is underlined.
highlighted part.
The wide definition of industry or the use of general words like any person and any purpose cannot free the whole clause from the inarticulate major premise that only a public purpose to subserve the common good and filling the bill of Article 39B and C will be permissible. Even a private industry may be for a national need and may serve common good. Even a medical clinic, legal aid bureau, engineering consultant's office, private ambulance garage, pharmacist shop, or even a funeral home may be a public utility. Professions for the people, trade at the service of the community, and industry in the strategic sector of the nation's development may well be in private hands in the transitional stage of our pluralist economy undergoing a Fabian transformation. Why should lands allotted to such private industries or professionals be condemned? The touchstone is public purpose, community good, and like criteria. If the power is used for favoring a private industrialist or for nepotistic reasons, the oblique act will meet with its judicial Waterloo. To presume as probable graft, nepotism, patronage, political clout, friendly pressure, or corrupt purpose is impermissible. The law will be good, the power will be impeccable, but if the particular act of allotment is mala fide or beyond the statutory and constitutional parameters, such exercise will be a casualty in court and will be struck down. I endorse broadly everything that is included here. Now, this is not a dissent. This is been endorsed as part of the majority itself. Now, if I can trouble your lordship, I'm done with this note. If you can just come to note 2M. To M. The first point is that there is no revival. Do all my lords have 2M?
Yes.
Justice Masi has it?
Yes.
Yes. 2M, the first is that the word revival is a misnomer because there has been no death at all. Your lordships can skip the first three bullet points. The fourth one refers to Annexure 5, where there's a list of cases dealing with what the effect of void is. I'm not reading it, your lordship may see it, but the void, effect of void, which is common to 13.2, which is common to 368, and which is common in this kind of circumstance with a basic structure violation, is that everything is effaced all the way to the beginning. It's, as Mr. Salve put yesterday, entirely stillborn. If my lord will see the last bullet point, which is interpreting Article 368. As per 368.2, the effect of a valid amendment is, this is from 368.2, that the Constitution shall stand amended in accordance with the terms of the bill. So if it is struck down, it means it shall not stand amended, which means there's no amendment at all. That's the effect of it being void. Because it uses the word shall stand amended. Therefore, it shall not stand amended now if the amendment is not there.
Yes, we got that.
Next one is that it applies to the Constitution. The primary point is the onus is entirely on the petitioners when they say that the doctrine of revival does not apply to constitutional amendments. The doctrine of revival applies to statutes. There's no doubt about that. There's a whole series of judgments. I've put it on at Annexure 6. A whole series.
Statutes also, there is a principle that a repeal of a repealing statute.
Yes, that's a general.
Does not revive the original
Correct.
statute, subject to any intent to the contrary.
Correct. Yes. No, that's been fully dealt with in NJSC, so I'm not going to go through that all over again. Here, the question is, you have taken one principle out of dozens of principles that we apply day in and day out in courts in this country. Whether it's res judicata, whether it's special versus general, later versus earlier, etc. All those provisions apply whenever your lordships are interpreting statutes of any sort. Suddenly, a barrier has been put up, as far as we are concerned, and told, sorry, that all that applies to legislative enactments. For some reason, it doesn't apply to constitutions. Why it doesn't apply to a constitutional interpretation is for them to discharge, which from that day in 1997, when they sought this reference till today, they haven't discharged this onus. They've raised the question and left it hanging as to why, when you have in constitution bench after constitution bench, this court has applied this principle, why suddenly when it comes to the Constitution itself, you will say no. There is suddenly an onus on us to show how it applies, when in fact every other principle we have applied.
They have touched upon this pen and ink theory, which they have not elaborated.
Correct. So I substitute that phrase, I'll address it right now. I'll substitute that with pen and eraser, and I'll explain why. When there is a substitution of a provision, whether it's in a statute or whether it's in the Constitution, when there is a substitution, it starts with erasing. So you rub out the words 39B and C, and then with your pencil, you put in Part 4, all the provisions of Part 4. Now, there are two aspects. This is linked to what Mr. Dwivedi addressed, your lordship. There are two aspects then. You have first done a deletion, and then you've done an insertion. Now, when both are struck down, your penciling is reversed and your erasing is reversed. So you're back to square one, you're back to what was there at the inception. So this principle of pen and ink has evolved both here and abroad in the context of provisions of law. No distinction has been made saying, oh, in a constitution, suddenly we will not apply a perfectly logical principle. There is absolutely no reason why it should not apply the Constitution. So the onus is on them, which they have not discharged. The second is, and this has been pointed by our side many times, that the question that was referred was only from 3 to 5 judges. This doctrine of revival. It was never renewed from 5 to 7 or 7 to 9. It was only at that stage from 3 to 5. And that has been answered by this court in 5 judges in NJSC. So if it's been answered, the question, that very question, whether doctrine of revival will apply to constitutional provisions has been answered. If it's been answered, then A, it doesn't survive for answering now. B, it's anyway been answered and it's not so perverse that it needs to be disturbed.
Mr. Shankaran, I think
I'm wrapping up. That's why I'm going much quicker than I would. I'm skipping whole bunches of points because this is just a 3.5 page note and I'm almost done. On 31C, there are 8 Constitution bench judgments. 8. I've listed 6 here. There are 2 more which deal with electricity, Thane Electric and Tinsukia. All these, this is point 7 at page 3 of this very note. These 8 judgments all deal with this provision specifically. all of them deal with 31C and treat 31C as existing in the form in which we argue it exists today. But most importantly, Coelho, which is 9 judges, which is important because it's a unanimous 9-judge judgment, employs the word at para 52 of Coelho. I'll just read that sentence out. In Minerva Mills, while striking down the enlargement of 31C. This is a coordinate bench's understanding of what 31C did, that it enlarged from just 39B and C to the entirety of Part 4. This is the sentence at para 52 of Chief Justice Agarwal's judgment. So the enlargement and the fact that 31C in that state stayed rooted after the Minerva Mills decision, without a doubt, from 8 constitution benches, including a 9-judge one.
What is that sentence read like?
In Minerva Mills, while striking down the enlargement of Article 31C through 42nd Amendment, which had replaced the words of or any of the principles laid on Part 4 with the principles specified in Clause B or Clause C and Article 39, Chandrachud GA said, and they've referred to Section 4 of the Act, and then they've gone on to para 53. But the understanding was that was an enlargement. What the effect of it was only a mere enlargement. So you open the door a wider crack. That door has been shut by Minerva, and that's the understanding and how 31C has survived throughout. Now, therefore, a long, consistent understanding constitutes stare decisis.
Yes.
One large substantial point now at the end, which if your lordships will see, absurd consequences have already been dealt with. In fact, it will surprise your lordships to know, perhaps you know it already, that this 42nd Amendment, to the extent that those words socialist and secular were inserted, has been challenged before this court by Mr. Ashwini Upadhyay. Yes. And it's pending, it was listed on Monday. Now, if he were to, by some strange means, succeed, then the entirety of that would disappear from the preamble, because what they did was not insert 2 words, they substituted the entirety of it. There are many other examples.
To Mr. Upadhyay's creativity.
We will, but I'm just giving. So annexures 9 and 10 give an illustration of all the provisions in the Constitution where there has been either omissions or there have been substitutions, and the effect of that, particularly annexure 10, your lordships may see. And now, my lords, Roman law, annexure 11, I have mentioned the roots of that and what I believe. I put a chart to show what could be covered. The last point is an important point, and this is when any of these matters come up for decision-making by a smaller bench, which is their suggestion, that apart from these other questions, they'll take everything else. The important aspect is going to be about Article 14, 19, and the reliefs that can be granted by courts. Today, unfortunately, because of this recent development, we have a situation where on Article 14, there seems to be a divergence of opinion in this court on the reliefs that can be molded when there has been a finding of a violation of a fundamental right. The recent judgment in Supreme says that the Constitutional Court has evolved over years till a stage now, where once the court has found that there is a discrimination that has occurred as far as the citizen is concerned, it is an obligation of the court to ensure that a relief is molded and provided. Maybe in the interregnum, maybe permanent, whatever it is, a relief has to be granted. The majority view is there is no incumbent need to provide such a remedy. Now that judgment, the majority judgment, is very clearly per incurium, because there are 3 Constitution Bench judgments which have not been considered by it. No, I didn't even appear in that case. And Mr. Solicitor, please take your seat. You can't interrupt like this. I'm not on anybody's side. I'm assisting a constitutional court. Now, it is necessary for the purposes of the Constitution and its interpretation. Yes. Mr. Mehta has heckler's veto in this court, clearly. Whenever he's done, my lords, if I can continue my address. Now,
Yes.
it is necessary for this court to settle the position.
Already got the point.
Now, no, I'll
Don't
just
have to
explain.
specify.
I've mentioned in the note the 3 Constitution Bench judgments, one of which was cited in the SEC online version of this judgment. All the arguments placed by the various counsels are also provided, which shows that Mr. Ramachandran specifically referred to one of these judgments, yet the majority doesn't even refer to it. it is squarely on the point, the fact about relief molding when Article 14 violations take place. Now, if I may say, a 5 judges bench cannot take that call of another 5 judges bench being per incurium. So that will compulsorily eventually have to go to a 7 judges bench to decide. I would suggest that your lordships may declare the law one way or the other. Just consider this, it's very critical. Because everybody, all citizens need to know that if I have a violation of a fundamental right and I come to this court, is the court going to follow? There isn't. But since it's a pure question of law,
Motto will take it up in the.
your lordships have that. Your lordships have the authority to take up any question of law.
There are many counsels on that, not your argument.
No, that's fine. Your lordships can take it up. I'm leaving it entirely. I have to make the argument because I think there's an obligation to make the argument. That may be. I'm assisting on my own. Yes, I'm assisting on my own. This is my submission on my own, which I'm entitled to. I don't need anybody's permission to make a constitutional submission.
Lord,
I don't need anybody's permission to make submissions in this court. I'm grateful.
Lord, this is neither center submission, this is not state of Maharashtra submission.
It's not.
And Mr. Dwivedi said it's not submission by the state of West Bengal.
It's not
really unfair that we have to give rejoinder to somebody who is supposed to be, Lord, arguing the same point, Lord, which we are arguing. I'm saying this respectfully. I won't be able to be rude or Lord, rustic. That's all.
I'm not even remotely claiming it's anybody's instructions. As a lawyer assisting a constitutional court, I don't need instructions on a pure question of law.
The court has not appointed you, Amicus.
That's okay, I'm not. I'm grateful, man. I'm most.
All right. Yes, Mr. Diwan.
Yeah.
Mr. Diwan, leave some time for the rejoinder.
Well, Mr. Andhyarujina assured me at the lunch break that he'd used his persuasive powers to urge you to sit beyond 4 p.m. As you have
I don't
in
know
the
about
past.
that, but Lord, I have used
I
my
will
persuasive
support
powers
that
on my solicitor to
question.
delay my flight. But I don't know if I can persuade your lordships to go 15 minutes later for tea perhaps. That's about it.
All right, then I'll go as swiftly as I can. I'll just mention the points. So first, my lords, I am appearing for the JVPD Tenants and Residents Association. I am respondent number 3 in writ petition number 660 of 1998. JVPD Tenants and Residents Association. Second.
We have not made any submission.
He's basically arguing a question of law.
I thought I should identify my.
Nothing on the facts. Nothing on the facts on who these tenants are. We have the learned senior counsel giving us some new ideas or inputs. That's all. Nothing more than that.
My written submissions are in volume 2O. I will supplement those with submissions that with an additional note. But let me just indicate to you that I will make points because time is short, and I'll make those points under 5 broad heads. And if your lordship feels that one is straying, your lordships will indicate that I should sort of curb it. Let me just preface this by making 2 statements. The first is that your lordships in a constitution bench in KK Kochini my points. So before I give you those clusters of under 5 clusters of points, there's just 1 or 2 prefatory remarks I want to make. So your lordships, on the 4th of March 1959, in a constitution bench of 5 learned judges in KK Kochuni's case, which is at volume 5H and the relevant paragraph of that judgment is para 11. I'll just state it. Said that this court,
What page?
well, it's just, in this volume, there's just one page, so it's volume, I think, if your lordship likes, I can give you the citation.
No, that's fine. Kochuni.
Yes, KK Kochuni, it's 59 sub 2 SCR 316. But in the version which we have given you from SCC online, there are paragraph numbers. The relevant paragraph number is para 11. And this is for the proposition because a contest was there as to whether this court could issue declaratory relief.
All the learned counsel, please start citing now the digital SCR because I can't
Digital
tell you
SCR.
how much, yes, how much our team has worked on it and we have brought it up. It's the official report.
We'll put it
Absolutely
there.
up to date.
Yeah.
And please do cite our official law report now.
We'll do.
With the neutral citations, we also have neutral citations.
Very well. We'll do that. So, Manoj, the contest.
It's like a book. It's not even like a PDF in a PDF form. ESCR was in a PDF form. DGSCR, in fact, you can just, while sitting here, just surf it on your iPad. It's in the book form. You flip a page as you flip a book's page. Yes.
So, Manoj, Kochini was on the case because at that point of time, there was a contest and a preliminary objection raised as to whether this court under 32 could issue declaratory relief. And the contest was, were you required to file a suit under the Specific Relief Act? And the court said that no, we can issue declaratory reliefs. The only reason I'm mentioning this is, it's very important with regard to the nature of the declaratory reliefs, which your lordships have seen, granted in Minerva Mills. And here I'm just pointing out one para 75 has been placed repeatedly before your lordship.
So what is the principle from Kochuni that you are extrapolating, Mr. Diwan?
No, the only, this is just prefatory. Declaratory relief can be granted by this court to declare. Here, thereafter, I point to paragraph 75 of Minerva Mills, and please see the nature of the declaration. The language is absolutely clear. And insofar as section 4 of the 42nd Amendment is concerned, that is set out in Mr. Dwivedi's note in the Solicitor General's note, but you will find it at page 3966 of volume 4.
We saw that. Yeah.
Your lordships have seen that. Now, Manoj, I want to just mention a dimension which is under judicial review. So I'll just state the points under judicial review. If the submission of the appellants or the petitioners here is accepted, then in our respectful submission, it will severely impact the power of judicial review of this court. And that ought not to be allowed. Now, let me indicate how. First, judicial review has been accepted right from Keshavananda Bharti as an entrenched provision, an entrenched feature, and therefore it's part of our basic structure. Keshavananda, your lordships will find there are observations in Minerva Mills, in L. Chandrakumar, all to that effect. I'll give you the paragraph numbers, but this is very, very well established. Now, how does this cripple and undermine judicial review is the point which I am seeking to press. The theory being put forth is that on a correct understanding, when your lordships issues a declaration, or issues or strikes down a particular provision seeking to amend the Constitution, there remains a hole in the Constitution. So it's some sort of a Swiss cheese full of holes that will result, and you will have a Constitution with hole after hole after hole. Now that cannot be and ought not to be a policy or a manner of interpretation that ought to be encouraged. An interpretation should be encouraged where the court is focusing on what is the provision, how is it infringing a part of the basic structure, how is it violating certain essential fundamental rights or other features of the Constitution. Not that the court should be focused on, oh, what will happen after I strike it down? Because there will be X hole or Y hole, and you will have a number of holes. So that's my first point. The second point I wish to make is that as far as judicial review is concerned under our constitutional scheme, it is not codependent on any other limb or branch of government. It's a power entirely vested in our constitutional courts. The theory being suggested by the other side is, and it develops and requires a codependence, between not just the court, but also the court and the legislature to fill a gap. So I would respectfully submit that is contrary to separation of powers. It's contrary to the notion of judicial review, which is vested entirely and only in this particular institution. Do not please accept a set of submissions which will result in a situation where, despite your lordship's judgment and final declaration, there will still be something else required by somebody else for the purposes of a meaningful way forward. That's the second point. The third point I wish to make, which also touches on judicial review, is, so the third facet is really the efficacy of the judicial process. This severely undermines the efficacy of the judicial process if you are going to have a system or a suggestion or a theory which is accepted, which requires another branch in the shoes of Parliament. In my respectful submission, had Parliament known that these particular provisions were indeed unconstitutional and stillborn, they would not have enacted the provision at all. It would never have been the intent under Article 368 to remove Article 39 B and C. So they would, had they the knowledge or the understanding, when they brought about this particular constitutional change through Section 4, they thought, as your lordships correctly put it, they were expanding the scope. But had they known that this is something which will not pass constitutional muster, they wouldn't have done it at all. So therefore, the position we are canvassing, which is to say that the provision prior to Section 4, which has been now held to be unconstitutional and void, must obtain. Otherwise, of course, there are other submissions also with regard to the fact that there is that it will result in absurdity. But I am just placing this on another facet, which is judicial review. So that's my first set of points.
Oh, the first set of points, these four, right?
These are the points. Okay. Now I come to my second set of points. My second set of points is with reference to natural resource allocation case, the Constitution Bench judgment. Your Lordship will find that in volume 5D. And here, may I just place a few paragraphs. I'll just give you the paragraphs and then just place a few of them. According to us, the relevant paragraphs are 113, 118.
Volume and page.
Yes, certainly. My lords, it is in, it's in volume 5D.
Page?
D. And it is at page 474. It's the printed page 474. PDF is, I think, 476. 474. Then the discussion, yes, it's serial number 14 of the index. And the discussion on Article 39 begins at paragraph 113. Now, this was, as your Lordship knows, in the context as to whether...
130.
Yes, 113. My lords, I'm giving you the paragraph numbers.
Yes.
The relevant paras are 113, 118, 119, and 120.
Yes.
Now, if you permit, I can take you to PDF page 558 and just place it, or I'll summarize it for you. I'll summarize the point for you, Lord. What this court has held essentially is that, look, as far as articles of, I mean, the Constitution is intended to endure, and so are these provisions, particularly the directive principles of state policy, because they are to guide the legislature and all branches of government moving forward for as long as the Constitution endures. Now, in a situation such as this, the Constitution Bench in Natural Resources, in the paragraphs which I have indicated, thought there was great wisdom in giving a wide interpretation to each of the expressions which was used within Article 39, and to leave it to the wisdom of governments, and in fact they use that expression as well, of the future, to interpret, to create, to define. So I am relying upon this Constitution Bench judgment essentially to advance the proposition that there may be great advantage in a situation where we do not confine the scope of these particular articles and sub-articles and leave it to the future for governments to recognize their contents depending on the exigencies of that age. So that's, my lords, yes. So therefore, my lords, what the court emphasizes is that these are matters of policy, which the government will eventually take a call on when the legislature steps in. So, my lord, that's my second set of submissions. The third, my lords, I'm going to request your lordships to just go to a few paragraphs of Mafatlal Industries. So now I'm on my third set of points. So Mafatlal Industries, your lordships will find, is in volume 5 at page 2797. And here, may I just request you directly.
They argued that Mafatlal Industries, the point was in issue, it was argued.
Yes.
It was contested, and
Yes.
even the concurring judgment refers to
Yes.
that.
So I completely support, my lords, those
How do you
submissions.
formulate your point on Mafatlal?
So, my lords, I want to just point out that in paragraph 76, which your lordship will find at volume 5, page 2865, the context in which this discussion takes place is mentioned. So there was a judgment of Kanhaiya Lal,
Yes.
which they eventually overruled for this relevant particular portion. And it's in that context. So if you permit, I can just show you a few relevant paragraphs from that.
You can just tell us.
All right. So then, my lords, I'll give you the paragraphs. So please note the paragraphs of this particular, of Mafatlal. So I am relying on para 76, particularly subclause 4, because there's a discussion on each subclause of para 76 separately.
In fact,
74
was also cited, yes.
So 74 was cited. And then your lordships will just see that as far as the remainder paragraphs are concerned, the ones which, sorry, your lordship will just give me a moment. Just a second. Two 2875. Yes, my lord, the discussion in Roman 4 begins at para 83 on page 2875, and the portions which the Solicitor General has also placed are paragraphs 84 right through till 86. So it was very much, my lords, an issue, and this is a 9-judge bench. We commend the same approach to the court. So, my lords, I am done as far as this set of points is concerned. Now, as far as MADA is, as far as the MADA Act is concerned, I want, with your permission, I want to just read one of the impugned judgments. So, your lordships have made it clear that that will probably go before an appropriate bench to discuss it. But I'd like to read, with your permission, 4 paragraphs from Justice Pence's judgment.
Into that.
All right, then I'll give your lordships those paragraphs. It will explain to you the perspective, my lords, because he's dealing with this particular act. And what is this common community of resources? What is the common good in the context of the MADA Amendment Act? So I'll just give your lordships that judgment. The judgment your lordship will find is at volume 5, page 2655. It's at serial number 55. And the judge, sorry. It explains, my lords, it explains the context in which this whole statute arose. And I think this discussion, my lords, in the context of the peculiar circumstances which was confronting the legislature and the ground situation is set out and explained by the division bench of the Bombay High Court. May I just take your lordship to that? It's just volume 5. There are 5 paragraphs that I'll specifically point to. 2655, volume 5, serial number 55. Your lordships have it? The opening paragraph indicates the challenge to chapter 8A. Then please see, I'll just mention the paras I'm relying on. Paras 2, 5, 6, 13 and 14. 2, 5, 6, 13 and 14. Now just see para 2, for example. Before adverting to the challenge raised in the petition, it's necessary to refer to the legislative provisions which are relevant to appreciate the contentions raised in the petition. The land available for housing in the island city of Bombay is very limited due to the geographical limitations of Bombay city being the commercial capital of the country. The pressure on the limited availability of land is extremely heavy.
Sorry,
Sorry.
2655, right?
Yes, 2655. The prices of houses were always on the rise, and it is extremely difficult for persons belonging to the lower income group or even the middle income group to secure shelter by payment of rent, a reasonable rent. The legislature realized the plight of the people residing in the city as far back as 1938. The Bombay Rent Restrictions Act 1939 was not in excess of rupees 80 per month. After Second World War, the rents skyrocketed. And it was impossible for the common citizen to secure housing accommodation in the city. The break of war resulted into shortages of building material, and the government was required to step in and issue orders under the provision of the Defense of India Rules 1939. In the interest of the legislature thereupon enacted the Bombay Rents Act 1947 to replace the earlier acts. The Bombay Rent Act covers the towns of so-and-so. The Vidarbha region is governed by the Rent Control Act, and is known as the Central Provinces and Berar Letting Act. Then please go, the dominant intention of the legislature in enacting the Bombay Rent Act was to uphold protection to the tenants from wrongful eviction, and also to ensure that the tenants are able to secure housing accommodation at a reasonable rent. With the object in view, the Rent Act provided that the landlord shall not charge rent in excess of the standard rent, and the expression standard rent means that the rent that was payable for the premises on September 1st, 1940. In other words, the legislature had frozen the rent which the landlords were recovering on September 1st, 1940, and has issued a fiat not to recover rent in excess of the standard rent. Then please go on, if your lordships would, to paragraph 5. On February 26, 1986, the governor of Maharashtra issued an ordinance, being Ordinance 1 of 1986, to amend the MHADA. The ordinance was converted into Amending Act number so-and-so. The statement of objects and reasons of the enactment of the amendment sets out that there are
my learned brother says that you have given the gist of Justice Paine's judgment in 2O page 60. So
yes, it is. So your lordships will see examine that. But essentially, my lords, what the judge says in the remaining paragraphs, which I was planning to read, was basically that, look, there is this huge stock of housing. There are these tenants which are affected. This is a community resource, citing the preamble to the enactment, etc., and explains as to how and the context in which these statutes came to be passed. So that was really the purpose in which, so it takes various different dimensions, is the point which I wanted to make, and we have summarized this in our list of dates. Finally, my lords, I might just mention this to you. So, my lords, this is essentially, I wanted to just contextualize the act. I believe the division bench we are not deciding on the correctness of the judgment here in this combination, but it sets out the logic of the legislature and eventually upholds the amending statute, which is, of course, subject to challenge before this court. My lords, my final set of points are really with reference to the written submissions which we have made. And here may I just mention 3 paragraphs or 4 paragraphs to your lordships. 35N, I've indicated to you as to where my written submissions are placed. It's in volume 2O, and I'll just highlight without reading them 3 or 4 paragraphs. So there is 35 subpara N at page 25, paragraph 39 at page 27, 40 to 41 at page 31 of volume 2O. Now let me summarize as to what we have included in these 4 or 5 paragraphs that I'm just mentioning. One set of submissions that we have made are with regard to this notion of premium or pagdi, and on the basis of the material which was available and culling out from the material which was also before the legislature and which was put in the statement of objects and reasons. So, for example, my lords, there is a reference in our written submissions that the committee, my lords, ahead of the 1999 Rent Act, estimated that between 1947 and 1997, more than 70,000 crores was paid as premium or pagdi. So the legislature is aware of these premiums. Of course, the 99 Act, as your lordship knows, legalized pagdi. Prior to that, it was not legalized. So these are some of the features, because there was an emphasis, and I don't blame them, saying that, look, these rents have frozen in some certain situations, it is most unfair. So all I'm pointing out in these three sets of paragraphs is that the legislature has counterbalanced as far as the interests of landlords, etc., are concerned by legitimizing and legalizing pagri, though pagri was as a matter of practice going on even under the old regime, number one. Number two, it has permitted certain sets of transfers to be allowed in terms of premium. A second part of the package was that certain types of companies with turnovers, multinationals, etc., were brought outside of the remit of the Rent Act. A third was that there was an escalation which was mandated by the Maharashtra Rent Act. So that will again be looked at by the appropriate bench. But there were a package of measures which your lordships have noticed. And I thought we should just mention this. There are references in in the written submissions we have filed to in our footnotes to various affidavits, should that necessity arise. So this is my respectful submission. I'm very grateful.
Yes, Mr. Yes, Mr.
Mr. Andyarujina would be arguing for.
We have to give now everybody 45 minutes. So maybe if once Mr. Andyarujina finishes, if we have a little time, we'll give you a hearing.
Well,
Yes, Mr.
I just wanted to point out the volume numbers.
Give us a small one-page note. Yes.
Only two small points, and then I'll.
Yeah.
Well, also, the claimant, the petitioner appellant side has filed written submissions from A to I. H and I are written rejoinder submissions. H is filed by Mr. Andyarujina, I by me. And the respondents have filed volume 2, A to U, 21 volumes are the rejoinder submissions.
Yes, Mr.
Well,
But, I find, my lord, that but I have circulated a rejoinder note, but, which, my lord, by some small miracle, more or less covers everything that my colleagues have said today as well. But may I request your lordships to see that?
Where is that?
But it is called 1H. Lord, and given the fact that, Lord, we are constrained for time, Lord, my approach is to show your lordship the material from which I put into the note.
1H hai kya hamare paas?
But it looks like this.
it's been emailed and put on the Google Drive. The link. We've emailed it also about
Upload
half
kar
an hour
lijiye.
back.
But till
He just uploaded.
till it comes to your lordship, Lord.
Just take 1 minute.
Sure,
Just wait
please.
for a second.
Lordships and I have a common objective, Lord. But the lordships to bring this to an orderly close, Lord, need to reach the airport in time. So Lord, hopefully we'll both get there.
Mr. Andyarujina, the pull of Delhi is infectious.
I have noticed that. But there are certain sort of gravitational forces in Bombay as well, as your lordship knows, but it is. Especially if your lordship is.
Have gone into
All over any of the
cheese holes. And the arguments, I think Mr. Shamjivan brought his arguments from the kitchen cellar. So,
Lord, your lordship was very euphemistic. Lord, your lordship didn't say the junk mail folder.
No, no.
Obliged for that.
Yes.
So hopefully we'll find it. Extract it.
yeah, so.
Rejoinder. Thank you.
I was acting as a mouse, you know. Onto a cheese.
It's a deadly combination, huh? The mouse and the blue cheese, as they say.
Only virtually. Only virtually.
But I've gone vegan, so cheese is out of question. Yes.
But if I can just step back from the note for 1 minute, because a lot of material has been used before a lot.
Yes.
Submissions have been made. But my attempt in the rejoinder is to, in one sense, give some order to this material. I'm not the first point I want to make to your lordships. I believe that this is a not significant point given the time spent by my lordships. But it is a conceptual error to conflate the idea of voidness, whether it is voidness ab initio or otherwise, with the doctrine of revival. I'm not going to tell you, Lordship, why I say this. But and I was fully conscious of this when I made my own, and therefore I didn't elaborate on the aspect of voidness. Voidness is something that goes with the declaration of unconstitutionality, as your lordships make it. But it is a doctrine which deals with the effect of lordships declarately order the statute. It makes no difference in my respectful submission whether it is sure. But the cases are settled on this aspect. The effect is to rob it of all legal effect. It becomes legally destitute. Now, my learned friends, for arguments, proceed on the basis that because it is void, we must treat it as factually non-existent in the statute book. But in my respectful submission, that is to conflate two different concepts. I tell you, Lordship, why. But I understand this requires a little bit of explanation. Bear with me a minute. But I don't think there is any dispute about the fact that your Lordship's declaration, and I'll deal with the different types of voidness because I noted carefully what my Lord the Chief Justice put to me the other day. Lord, renders the decision void at some level. You may say void on the date of the declaration. You may say void on the date of insertion. You may say void on the date of amendment. But all of those are statements which go to the legal effect of the remaining language. That, in my respectful submission, is not really the point that we are grappling with. The real point that we are grappling with is a question which is apart from this. It is the question of whether the old provision can be resurrected or come alive again. Now, my learned friends in their argument, and I notice
their argument is that the old provision never died in natural death.
It is always latent and it is always there.
Because because the process by which the new provision was sought to be inserted in substitution of the old provision, that itself was stillborn. So in that sense, it was not the substituted provision which ceases to be of effect, but the substituting provision ceases to be of effect.
I fully appreciate that point. And my response to that point, Lord, is twofold. But one is what I've already said, the pen and ink theory. But we may regard that as some sort of abstruse doctrine of constitutional law. So, Lord, I actually have a better answer for you. Lord, and the answer is this. Lord, that when we declare something to be void, we rob it of legal effect. Lord, it is something that courts do day in and day out. But the voidness doesn't carry with it the consequential actions which may follow as a result of the voidness. But in this case, the legislative cleanup or the legislative sweep up or the legislative reenactment. Now, when your Lordship puts it to me to say that, as my learned friend Mr. Shankar Narayan put it, that in fact it's never dead. Lord, I respectfully disagree, but I see a situation where that could be the case. Lord, where under Article 368(2), the procedure for bringing about a constitutional amendment has not been followed. The law has never taken effect as prescribed by 368(2), it is entirely possible to say that the old law has not been dislodged and the new law has not become alive. So, my lord,
But if the basic structure is a limitation on the amending power
Yes.
itself,
Yeah.
in which case compliance or consistency with the basic structure is a condition precedent to a valid exercise of the amending power.
I see that point.
And then if the condition precedent is not fulfilled, then the process of substitution itself never took effect.
So let me immediately try to answer that point.
And that's why the declaration that section 4 was void was all that was necessary. They didn't have to go all the way to say that 31C is void. Because if the substitution had taken effect, they would have had to declare 31C as void, which they never did. They said that section 4 is void for the reason that the substitution was never carried out as a matter of constitutional doctrine. That seems to be the line of argument.
So, but let me try to answer your lordship, my lord, with 3 or 4 points. But the first is this, my lord. There are various types of voidness. Lord, voidness for lack of legislative competence. Voidness for
Breach of fundamental rights
under part
any other constitutional limitation, and basic structure.
and basic structure. Now, my lord, basic structure, my lord, has actually received its own nomenclature, as your lordship has noticed from Minerva. And the correct nomenclature, but we don't need a new nomenclature for that, is beyond the amending power of the Constitution. That is the language which is consistently used when it comes to basic structure. So, my lord, we are in a situation, although a judge-made situation, of akin to legislative incompetence. Akin to it. We are in a situation where it is a limitation on the constituent power. Therefore, my learned friend, Mr. Dwivedi, used language with regard to the using constituent. But it has already been dealt with by our courts. And what they say is that it is
Now,
beyond...
because the basic structure doctrine is a limitation on the amending power,
Yes,
and something which is done in violation of the basic structure is beyond the amending power.
ma'am.
That means that that exercise itself has no constitutional.
So, my lord, does it mean that is what I just want to
It
explain?
has no constitutional foundation. It's
Yes.
not that you have enacted a valid law, inserted it into the statute book, and then law happens to violate part 3 of the Constitution.
Madam.
Here, it's a situation where you have acted on an area where you had no power whatsoever. You are beyond your amending power.
I follow.
In which case, it doesn't enter the process of an effective constitutional amendment. It doesn't enter the constitutional fabric of 31C. It remained at a stage anterior thereto, namely an exercise by the Parliament, purportedly in the exercise of its power under 368(1).
I follow what the lordship says. But my response to your lordship, my respectful response to your lordship, Lord, on this point is this. Lord, the lack of constituent competence, Lord, which is the basic structured point, Lord, is very akin to the situation where there is a lack of legislative competence. It is almost identical. Lord, and therefore, Lord, I thought a great deal about this. Lord, there are many cases which deal with lack of legislative competence in the context of normal statutes. But in
There's
the
one critical difference.
Yes,
where there's a lack of legislative competence, the power to enact the law vests somewhere in the system.
Yes.
See,
I follow
because
what lordship said.
in the case of a breach of the basic structure, that power does not exist in any organ of the state.
Lord, I accept what your lordship says there also. Lord, so the basic structure doctrine is an implied limitation. It is an implied limitation which prevented that particular amendment from being passed. Lord, I accept everything that your lordship said. The effect, therefore, of your lordship's declaration of unconstitutionality, let us take it at its strongest, declares it void ab initio, as if it never existed. But my lord, my point to your lordships is this. The statement of voidness is a statement limited to legal effect. Now, Lord, allow me just to elaborate this. Lord, what happened, Lord, with regard to this particular amendment? And Lord, and I just want to draw a distinction where I believe that your doctrine, Lord, holds, where what your lordship put to me holds true. But if your lordship takes up my note for a minute, Lord, I have set this out to just prevent us from having to go elsewhere for it. But please come to paragraph 16 at page 111. Now, my lord, my point to your lordship is this. And here I want to deal with one of the points raised by my learned friend, Mr. Dwivedi. But paragraph 16, if your lordships have it, at 111. But perhaps at paragraph 15, Your Lordship will get a broader idea of what I'm saying there. But the point, another way of looking at the point is the point which was also made by some of my learned friends, Lord Mr. Salve, Mr. Dwivedi, Mr. Shankar Narayan, to say that view section 4 in isolation. Don't view it as becoming a part of 31C. So what I'm trying to deal with that point. Your Lordship, have it. Paragraph 16.
At page?
What is that? Page 111. 111.
The note is only page 22. PDF page 6. In the note, right?
PDF 6, I believe. Your Lordship is right.
16.
In section 4 head, begins as section 4 head.
Not it becomes section 4. But I just refer Your Lordship to the paragraph before that if Your Lordship doesn't mind. What, para 15? Para 15. All of Your Lordships. What the argument that the order and judgment in Minerva Mills merely struck down section 4 to be unconstitutional and not, it should say Article 31C as amended by section 4 is stated to be rejected. Section 4 had, in accordance with subclause 2 of Article 368, resulted in Article 31C standing amended in accordance with the terms of the bill on 18th December 76. So not first is the factual position. From this day onwards, Section 4 was a part of Article 31C and Article 31C stood so amended. Any declaration of unconstitutionality with regard to Section 4 after 3rd January 77 is necessarily to be read as a statement of unconstitutionality with regard to Article 31C as amended by Section 4. Now, look, to this point, please have a look at the order passed in Minerva Mills. Not I've extracted it, but if Your Lordships would kindly go.
No, but the logic you are trying to make, read further. There are 17 and 18.
Yes, sir.
Then it makes sense what you are saying.
Yes, sir, I will. Sir.
That they have already answered. You read para 70 so that
Yes,
it becomes.
17, please, no. From this day onwards, Section 4 was a part of Article 31C and Article 31C stood so amended.
Now 18.
18. Any declaration of unconstitutionality with regard to Section 4 after 3rd January 77 is necessarily to be read as a statement of unconstitutionality with regard to Article 31C as amended by Section 4. In fact, it is evident from a reading of the order in Minerva Mills that the Honorable Supreme Court also regarded it to be so.
In other words, 31C is not there.
But that part of 31C is no longer.
No.
Then what
What you are saying is 31C is not there. No part, no this. You are saying 31C is not there. This is what you mean, isn't it?
What I mean to say is actually the amended part of 31C is not there. But that's what I mean to say. But therefore, Lord, I regard this, that's why I call my note the dead letter. There is nothing meaningful left in 31C. That is the point that I seek to make to Your Lordships. But I see the fact that this is a conceptually difficult idea. Just bear with me a few minutes. Just have a look, Lord, at the order in Minerva Mills. But what did the learned judges think they were doing? But it's quite clear from their own statement. But please have a look, Lord, I've extracted at paragraph 10. I know we've read it several times, Lord. Just I'll be very brief with it. Paragraph 10.
Of your notes?
Yes, please. Of mine. I put everything into my note. Hopefully, I won't need to take Your Lordships elsewhere. But PDF 4. PDF 4. But if all Your Lordships have this book. The Honorable Supreme Court, by its order of 8th May in Minerva Mills, passed inter alia the following order as far as 31C is concerned. Section 4 of the Constitution Act, which came into force with effect from 3rd January. Now, please note the language of the court. Amended Article 31C of the Constitution by substituting the words and figures, all or any of the principles laid down in Part 4 for the words and figures, the principles specified in Clause 6 and Clause C of Article 39, It should say clause B, I'm so sorry. Article 31C as amended reads as under. Now we have the new article. Section 4 of the Constitution 42nd Amendment Act is beyond the amending power of Parliament and is void since it damages the basic and essential features of the Constitution and destroys its basic structure by a total exclusion of challenge to any law on the ground that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 and 19 of the Constitution, if the law is for giving effect to the policy of state towards securing all or any of the principles laid down in Part 4 of the Constitution. Now, Lord, I don't want to make too much of this, but, my Lord, the point that I do want to emphasize to your Lordships is that, my Lord, every precept of constitutional law tells us that once the procedure under 368 stands completed, we have a new amended article. And, my Lord, in my respectful submission, my Lord, the doctrine of voidness is not effective against that. Now, the doctrine of voidness, as your Lordships have rightly noted, is a tool at the hands of your Lordship for a variety of purposes. Void from the date of the declaration, prospectively void, retrospectively void, void ab initio. But, my Lord, to my earlier point, my Lord, this is a question of constituent power. My Lord, this doctrine of voidness does not bleed into constituent power. My Lord, if any separation is to be maintained, my Lord, it is with regard to constituent power. I can understand, Lord, and what my learned friend Mr. Dwivedi said, I understand its spirit, but I would put it differently. Under 141, your Lordship declares the law. But I fully understand that. Keshav Nanda Bharti itself, Lord, judge made law. The implied limitations, judge developed limitations. But, my Lord, at the same time, it is for your Lordships to strike that balance. Constituent power, the power, and that's why, my Lord, I take a little bit of difference with my learned friends when they seem to suggest that the doctrine of revival must be equated with an ordinary statute. But it may, in some cases, be the same in the case of substitution. But this is a power of a high order. Lord, it is given only to Parliament. There is a special procedure which is to be followed. And in my respectful submission, this doctrine, A fortiori, all the more applies to the exercise of constitutional substitution. Now, Lord, if there's any point I wanted to make in the rejoinder, I did want to say that the question of voidness does not affect the separation of powers and the constituent power of Parliament, which continues to reside only with Parliament. Now, Lord, it's often said, but this is a highly technical point you're raising, but it should be swept up. But my Lord raised an everyday problem. How do we know what is the law? Lord, if your Lordship's court is to work in perfect tandem with Parliament, Parliament should immediately step in and re-legislate in some way. Lord, it doesn't result in a void. It is resulting in a void because your Lordship's court has done its job, but Parliament has not, in my respectful submission. But there's nothing odd about it. There's nothing strange about it. In fact, my Lord, if we understand this way, it is in perfect harmony. The courts work with Parliament. You strike it down, Parliament may reenact. But in the circumstances which we know. So, Lord, in my respectful submission, it would be a conceptual error to conflate voidness with constituent power. That's
This was answered.
I'm so
This
sorry.
was answered by Mr. Diwan.
Yes,
Who said that, this is curtailing the powers of judicial review.
yes. I just want to deal with that.
Because if we depend upon whatever we decide as a judicial review, we depend upon the Parliament to rectify it, then where's the power?
Let me answer that immediately. Lord, as Lord has been said, Lord, by celebrated jurists, Lord, 32 is the soul of the chapter on fundamental rights. Fully accept that. But Lord, I ask myself, your Lordships, a question. Judicial review is always a limited doctrine. When your Lordships judicially review administrative action, your Lordship will set aside the decision, but can never take the decision for the decision maker. And that is the point of the balance. Your Lordship's power is plenary insofar as it resides in your Lordships. But there are limits. The decision must be taken by the decision maker. Parliament must exercise its constituent power. Lord, I, for one, with great respect, find it to be perfectly harmonious. In fact, I find the other interpretation of voidness to be something that requires a legal exercise and is not in consonance with the separation of powers. But I hope I've answered your Lordship's question. Judicial review is a doctrine of a limited nature, by its very nature, my lord. But when your lordships judicially review executive action, your lordships set it aside, quash it.
Was, are with the Parliament, 368 are plenary powers.
My lord,
They are limited by basic structure doctrine.
my lord.
Now, if it encroaches upon that, then it has to be declared as unconstitutional.
It does.
And then, after it being declared as unconstitutional, we still depend upon the Parliament to rectify. Where are we?
So, Lord, may I venture to suggest that your lordships have.
Then all the Keshwanand Bharti, they have no relevance then. The basic structure doctrine has no relevance then.
No, my lord, the basic structure doctrine, my lord, with the greatest of respect to this great doctrine that we have developed, my lord, goes so far as to make a declaration of unconstitutionality. Lord, those are the limits of the basic structure doctrine. But we must also accept the fact that the basic structure doctrine, Lord, in a slightly, it's not an uncharted sea, Lord, as was said in Minerva Mills, in a different context. So, Lord, we accept the fact that powerful as the basic structure doctrine is, it also has some cognate limits. Lord, when we say that this is unconstitutional, the courts intentionally do not say that revive the old. The courts are intentionally silent on that. And, my lord, they are advisedly so. Because.
What about the observations made in Vaman Rao?
Yes.
Which is a judgment which came later.
Yes.
After Minerva Mills, the author of the judgment is aware of what is stated in Minerva Mills. But nevertheless, there are observations in Vaman Rao. Should those not be read?
So, Lord, the observations in Vaman Rao do present a difficulty. Lord,
so it is with regard to another challenge. But the author of the judgment is aware as to what has happened when Vaman Rao was being delivered vis-a-vis Article 31C.
No, my lady is right. They do present a difficulty.
Is there any import from there?
But there is great import, my lord, in one sense, my lord. It could be argued that Vaman Rao is completely against my argument. Vaman Rao shows a consciousness on the part of those judges that in fact the old revived.
Yes.
But my lord, my answer to Vaman Rao is that we must understand the peculiar circumstances in which Vaman Rao moved in lockstep with Minerva Mills. It was not possible for the judges, my lord, in Vaman Rao to actually pass a decision on this aspect because it moved simultaneously along with Minerva Mills.
But the judgment actually came later, the reasoning.
It
in
did.
November
It
1980.
did. And your lordship is, my lady is right. And I would venture to suggest Vaman Rao is absolutely correct because it was dealing with a situation till the amendment. So the question in Vaman Rao is till 1976 when the amendment takes place, is it valid or not?
But chronologically, if you see, from the historical perspective,
Yes.
in November 1980,
Yes.
this court was aware of what has happened on 31st July 1980.
Yes. But there's no running away from that. That is,
Yes,
that is
they have not shut their eyes to it.
they have not.
Do about it.
Another thing,
It has to be
Mr.
read as
Yeah,
together.
Mr. Andaraj,
Please.
the basic structure doctrine, its strike law doesn't apply to the original provisions of the Constitution.
Well, only the amendment.
Right, and there's a reason for it. You can't say that some part of the original provisions of the Constitution are so out of sync with the overall theory of the Constitution as to be violative of the basic structure. In other words, however much you find that an original provision of the Constitution is perhaps out of sync with what the other part of the Constitution does, it's not hit by the basic structure. The basic structure doctrine is a limitation only on the amending power, right? Now, actually, the basic structure doctrine is a very curious amalgam of process and substance. It's a limitation on the power to amend the Constitution, which is a processual power. But those limitations are not of a processual character. Those limitations are born from the substantive provisions of the underlying Constitution. That is, you draw those limitations from the substantive provisions of the existing Constitution and read them as limitations on the processual power to amend. Therefore, in that sense, that's how we say that the basic structure doctrine is a limitation on the amending power. If you breach those limitations, the very exercise of the amending power was null and void. It's not a case where a provision which is otherwise inserted into the Constitution is held to constitute a violation of a substantive constitutional safeguard, like Article 286, which we saw in Sundaramaiah's case. This is a case where if you breach the basic structure, the very process by which you sought to amend the Constitution stands constitutionally invalidated. In which case, the very act of insertion doesn't see the light of the day.
So, I see that point, but may I, once again, attempt to answer it with 2 points. But if your lordship has any other point, I will deal with that. But the first is this, your lordship is perfectly correct, but the basic structure deals with amendments and the limitation on those amendments. But I would request your lordships to bear in mind that 31C itself came in by way of an amendment.
Right.
So, my lord, it was not, as it were, my lord, originally at inception in the Constitution. So, my lord, the basics...
And therefore, it could be challenged, it was upheld in Keshav.
Your lordship is perfectly right, exactly the point. It could be challenged, it was upheld in Keshav Nanda Bharti. Now, the second challenge was to this amendment. And therefore, basic structure was correctly deployed, Lord, against the amendment, to say, let us test it against the amendment. But when your lordship puts it to me to say that it renders the insertion as if it had never been, in my respectful submission, I would submit this is an extension of the basic structure doctrine. For this reason, Lord, the basic structure doctrine accepts the constituent power of Parliament, 1. Secondly, to your lordship's own point, Lord, it is a self-limiting doctrine. It doesn't go, for example, to the original features of the Constitution. So, Lord, basic powers doctrine, it has limitations. Now, Lord, this question is in one sense a question of where do we draw the line with the limitations of basic power.
But therefore, to sustain your argument, what we'll have to postulate is this, that though 31C as amended was held to violate the basic structure, the very act of amendment was complete. Once the precedent
That is my point. I don't think I could have...
No, that's right. According to you, the very act of amendment of the Constitution was complete at a formal level, certainly, because Parliament enacted the amendment, it passed the amendment, the President signed the amendment into law, and therefore it took effect. Now, the fact that it took effect and was held to be void is a subsequent event, but it took effect before it was declared as void. That's what we'll have to hold to accept your point.
Yes.
Lord, I think your lordship has put my point very articulately, but I, for myself, Lord, see no conceptual fallacy in that point. But, and I readily accept, give me a moment to Lord, elaborate on this, that your lordship's point would be perfectly correct if the procedure of 368(2) remained incomplete. It could never be written into law. Now that, Lord, I respectfully submit is a very important counterfactual indication that we have in the Constitution itself. 368 tells us that in a situation where it's not written into the law, it is not the law, it is set aside, the old law has not been displaced. But we have a constitutional lead in this regard, which is 368(2). It has now been written into the Constitution, right or wrong, it has been written in. Your lordship's court with the basic structure doctrine, Lord, has a wide sweep. I accept that. Lord, must be developed and can be developed further. But on its current recognition, in my respectful submission, stops short at this to say that I declare this to be unconstitutional. In these circumstances, Parliament must do its job again. Lord, I find that to be a perfectly harmonious and symmetric reading of the Constitution. In fact, Lord, this doctrine of voidness does great violence, for example, to 368(2).
No, and if Parliament doesn't do that,
but this is exactly the situation we have.
what happens then?
So, Lord, it is in effect, but it remains on the statute. It is ineffective, but remains on the statute.
So you are there drawing a distinction between the procedure is not followed.
Yes.
Or a situation like ours where the procedure is followed, but after having followed the procedure, the precedent has signed.
But
so according to you, that will not result in the, but then if the moment we hold that, we are directly finding fault with the declaration in Minerva. Because the Minerva declaration is only on section 4.
But if your lordships permit me to say, Lord, the Minerva declaration was flawless. Lord,
You
more
will have to hold that your declaration in Minerva was wrong and you should have invalidated 31C itself.
But Lord,
Which nobody has really argued.
But not as I see the order, and that's why I showed your lordship the order. The order invalidates the amended part of 31C. Or as I read the order, Lord, it invalidates that amendment. Now, Lord, I want to just
The
make.
clauses 4 and 5 of Article 368 also was struck down.
Exactly.
In Minerva.
Exactly.
But nevertheless, you see, we have Vaman Rao's observations.
Yes, my lord. So, my lord,
Despite this.
Yeah.
so, but my respectful submission with regard to Vaman Rao is that it should be understood in the limited context in which it was passed and the limited challenge before them, namely up to the date of the amendment. So, my lord, that is how I deal with these 2 points. Now, my lord, I just want to deal with a related aspect, my lord. It's already dealt with actually. My lord, the argument which is made to say that Section 4 of the Amending Act should somehow be viewed in isolation. Lord, I've already actually said what I want to say on that. But in my respectful submission, that is factually difficult to understand, given the fact that Section 4 under 368(2) became a part of the Constitution. It's very difficult to understand how Section 4, after that process is complete, can still be regarded as separate and distinct. It has now embedded itself in the Constitution. If you are going to declare Section 4 unconstitutional, by any system of logic, what you are effectively doing is rendering a part of the Constitution unconstitutional. So, not this argument, in my respectful submission,
Part of the,
Constitution as amended unconstitutional.
so that's it. You're right. Part of it is okay.
Yes, ma'am.
Whereas their argument is it has
They're
not
saying.
entered the Constitution statute at all.
But that I've already said what I did want
You
to
have
say.
said that the argument would have been right. According to you, the procedure was not.
Yes,
right.
I would readily concede that. Now, Lord, I move to the third point. Lord, much has been said, and I was trying to deal with it, Lord, when your lordships put it to me twice or thrice, parliamentary intent. So your lordship spoke about parliamentary intent, and one of my learned friends also spoke about that. And the submission was that parliamentary intent could never be to result in such an absurd situation. Your lordship put it to me also, parliamentary intent is relevant. Let us see what is the parliamentary intent. We must have some extrinsic view or material evidence on this. Now, my answer to it is this. Once again, parliamentary intent, what I would concede is relevant in this situation where it doesn't come onto the statute book. And Lord, one of the cases relied on by the learned Solicitor General, Lord, I put it in my note, and I'll just tell your lordship where. Lord, but para 20, Lord, at page 112 is exactly this, my lord. This is the state of Maharashtra and Central Province Magnesor. Exactly this situation where actually there was a problem of procedure. Exactly the situation. In these circumstances, the court said, let's look at intent. It could never have been the intent of Parliament to delete but not to bring about the substitution. And they expressly say, in this case, fortunately, we don't have the present problem because, in fact, it's not substituted in law. Now, my lord, I understand, I present your lordships with this problem, but, my lord, I, for one, don't see it as a problem, my lord. I see it as the ordinary working of the Constitution, which from time to time hands over the baton for Parliament to do a necessary action. But I find it difficult to conceive how your lordships would say that this is void and that is revived. As your lordship say, parliamentary intent, we must look into these matters. How is it to be decided? But it is best left to Parliament to do its job. And its job is this, that when such a situation arises, it immediately steps in and rectifies. So, Lord, in answer to that, is our judicial review doctrine falling short? Or are we falling short as the judiciary? The answer is no. Lord, the basic structure document has been stretched to the fullest, but it has limits, and now it is for the other arm, Parliament, to step in and take the corrective steps. But that is my respectful response on these aspects of the matter. Now, my lord, I just want to point out to your lordship,
what about, are you going to argue on 39B?
For a few minutes on 39, but can I make two more points on this?
Yes,
and then go?
certainly.
But I understand I'll be keeping your lordship
No,
perhaps a
can-
little later.
So what are the two
Not
more?
too much later. Not 2 points I want to make. Not the first point I want to make is that in Minerva Mills, there was a very interesting discussion between the learned Attorney General and the Solicitor General and the court. They requested the court to actually read down the amendment to its original unamended form. The court declined to do it.
You have quoted that.
I have quoted that here. And the reason it declined to do it is that, look, the amendment, by reading it down, is being made something it is not. In fact, it is the very opposite of what you have done by way of the amendment.
They also cite the law minister's statement in
The
Parliament.
lordship is right.
The reason why we wanted to amend
Exactly the
it
point.
was we wanted laws to be saved without the let or hindrance of the fundamental rights.
I am obliged, Your Lordship.
That's what the law minister
I am
said.
obliged, Your Lordship. Now, Lord, not in the
Paragraph 15 minutes.
So, Lord, the result which could have been obtained by another method, to read it down, was expressly declined by the court. They said we can't do that because that was another way of achieving this very method, that the unamended 31C survived.
Quickly read both the paragraphs.
Please.
64, 65.
Please.
We expected you to read 15 minutes before.
Page 5 of your note.
But yes, paragraph 11.
So as to understand whether your interpretation as propounded in para 12 is correct or not.
Please, allow me. But the learned, if your lordship follows that.
Yes.
But the learned Attorney General and learned Solicitor General strongly impressed upon us that Article 31C should be read down as to save it from the challenge of
Because one of your submissions is don't go by the operative part of Minerva. Don't just go by the declaration. If you read declaration alone, perhaps, as my esteemed sister said, Vaman Rao will not, it will spoil the show.
Well,
But try to read 64,
I'm obliged.
65 and then reconcile.
I'm obliged. Lord, 64. Lord, the learned Attorney General and learned Solicitor General strongly impressed upon us that Article 31C should be read down so as to save it from the challenge of unconstitutionality. It was urged that it would be legitimate to read into article the intended that only such laws would be immunized from the challenge under 14 and 19 as do not damage or destroy the basic structure of the Constitution. The principle of reading down provisions of law for the purpose of saving it from a constitutional challenge is well known, but we find it impossible to accept the contention of the learned counsel in this behalf, because to do so will involve a gross distortion of the principle of reading down, depriving that doctrine of its only or true rationale when the words of which are used inadvertently. The device of reading down is not to be restored to in order to save... Resorted to, but I'm so sorry. No, not to be resorted to, in order to save the susceptibilities of lawmakers, nor indeed to imagine a law of one's liking to have been passed. One must at least take the Parliament at its word when especially it undertakes a constitutional...
Now 60.
Now, but Mr. Palkhiwala read out to us an extract from the speech of the then law minister, who, while speaking on the amendment to Article 31C, said that the amendment was being introduced because the government did not want the let and hindrance of fundamental rights. If Parliament has manifested a clear intention to exercise an unlimited power, it is impermissible to read down the amplitude of that power so as to make it limited. The principle of reading down cannot be invoked or applied in opposition to the clear intention of legislature. We suppose that in the history of constitutional law, no constitutional amendment has ever been read down to mean the exact opposite of what it says and intends. In fact, to accept the argument that we should read down Article 31C...
Now this is important. So as to make it conform to the ratio of the majority decision in Peshwan and Bharti, is to destroy the avowed purpose of Article 31C as indicated by the very heading, saving of certain laws under Articles 31A, 31B, and 31C are grouped. Now read further.
Obliged, Your Lordship. Since the amendment to Article 31C was unquestionably made with a view to empowering the legislatures to pass laws of a particular description, even if those laws violate the discipline of 14 and 19, it seems to us impossible to hold that we should still save Article 31C from the challenge of unconstitutionality by reading into that article words which destroy the rationale of that article and an intendment which is plainly contrary to its proclaimed purpose.
Now, para 12 is your interpretation,
Yes, ma'am.
right?
Or I hope it.
Even if we accept it, you will have to still overcome Vaman Rao.
Yes,
So first hurdle, you have to overcome this.
Yes,
Vaman Rao.
From the aforesaid,
yes. From the aforesaid, it is evident that Chief Justice Chandrachud expressly declined the suggestion by the learned Attorney General and learned Solicitor General to read down Article 31C to save it from being declared unconstitutional. The reasons in paragraph 65, namely to accept the suggestion and argument of reading down so that it would conform with the ratio of the majority decision in Keshav Nanda Bharati, is to destroy the above purpose of 31C as amended, indicated by the very head saving of certain laws, makes it evident that Chief Justice Chandrachud declined the suggestion that the statute should be read down to its unamended form.
arguing.
So, Lord, to my Lord Justice Padiwala's point, Lord, I've already said two things with regard to Vaman Rao. Lord, one, the circumstances in which it was passed. The second, the fact that it was dealing with a pre-amendment situation. And perhaps the third is that they were two.
So your argument is that Minerva Mills merely struck down section 4.
Absolutely.
That it merely struck down section 4 to be unconstitutional, but the entire 31C as amended.
The amended part stands struck down. That is my argument precisely. But it is not the entire 31, because 31, of course, was the subject matter of Keshav Nanda Bharati. So, my Lord, it is the amended portion
Then
which
we are
stands
again
struck down.
back to square one. Then we have to only read the operative part of Minerva. There is inconsistency in your submission.
Which means 39, B and C also go. That's logically.
To be precise, come to para 15 quickly.
And if 39, B and C also goes, what is the purpose of 31C?
This is what you are trying to drive.
But may I come to your Lordship in just a minute? Just a minute.
Para 15.
Please.
The argument that the order and judgment in Minerva Mills merely struck down section 4 to be
Yes,
unconstitutional.
that is what I said.
Article 31C as amended by section is stated to be rejected.
No, your Lordship is right. My Lord, so, my Lord, I do say that Article 31C as amended has been struck down. No, my Lord, the problem, of course, my Lord, which stares all of us in the face is Keshav Nanda.
Yes, that's.
It is, so my Lord, there are two ways of doing it, to be fair. My Lord, one is, my Lord, irrespective of Keshav Nanda Bharti, 31C is struck down. The other is that the amendment in 31C is struck down. There are two ways of viewing the problem. There are two ways of viewing the problem. It is a difficult conceptual problem, but not it is there. It requires to be solved by our lordships. Number one, I just want to say 2 or 3 more things on 31C, if your lordships will permit me. Well, the NJAC judgment in 2 minutes.
Yeah.
The NJAC judgment.
That's the problem we have to solve it.
But I do hope I can assist your lordship in a few minutes with that. Not the NJAC judgment. Not my short point on the NJAC judgment is this. Not it is only Justice Kehar who grapples with the doctrine of revival. Point number 1. Not the other 2 learned judges, Justice Kurian and Justice Goyal, will not say that of course it must be so. But they don't actually grapple with the doctrine. So, Lord, there is no reasoning with the doctrine of revival. Justice Chalmeshwar dissents and Justice Lokur expressly says that I want to leave the question open. So, Lord, in my respectful submission, there are 2 or 3 points that emerge. The first is this, that there is no discernible ratio from the NJAC judgment. To read a single judgment in this regard, in my respectful submission.
Music to the solicitors' ears.
No, but on this aspect, not only on this aspect.
Well, if that line comes in 9 judgment, on the lighter side.
But on this aspect, not on this aspect, Lord, of revival, Lord, it has no precedential value. That is the first. The second, Lord, of course, that your lordships put to me and immediately notice, the 99th Amendment is not a case of substitution, it's a case of supersession, which has also been noticed in the Zail Singh case, which my lady put to me. That is what I wanted to tell your lordship very briefly with regard to the NJSC judgment. Lord, just to conclude the 31C point, my lord. Lord, everything I have said, Lord, does not result in a constitutional vacuum. It does not result in a constitutional crisis. I take your lordships back to the words of Minerva Mills, where the learned Chief Justice, Justice Chandrachud, said that if the pith and substance of 39B is what the law is about, we have no fear of a challenge from 14 and 19. And Lord, the third point I leave your lordships with is that Lord, there are some possible problems with the Coelho judgment, with Article 31C, Lord, about what is the effect now of the remaining part of 31C, given the fact that 14 and 19 have now been defined as being part of the basic structure. But it is best that Parliament should re-legislate on this aspect. So, Lord, that is what I wanted to say with regard to 31C. Now, Lord, a few minutes, if your lordships would, Lord, indulge me, Lord, on the second aspect, Lord, which is the 39B aspect. But may I?
Yes.
Lord, 39B, first point, Lord, is can we say that the judgment in Mafatlal is actually obiter? Lord, my learned friend, the Solicitor General, did forcefully argue that, in fact, it was noticed and applied, and therefore it cannot be obiter.
It is discussed and applied.
But in my respectful submission, Lord, the question is whether it is obiter on this point. The point that we are discussing is whether private interest should be included within 39B. On that, it was a passing reference, merely saying that Ranganath Reddy onwards has recognized it to be so. Yes, it is true that it was then accepted as true and applied, but as far as this point is concerned, it was certainly obiter. So, Lord, it was applied in the context, as your lordship knows, of the tax which was already collected. And the question is, do you give it back to the assessee when the assessee is already passed on the burden to the customer? Or do we then distribute it for the purpose of 39B? So there was no decision on this aspect of the matter in Mafatlal. In my respectful submission, obiter it is. Now, Lord, I have got late in the day, but upon having the benefit of your lordship's points, Lord, and heard my learned friends, Lord, I want to suggest to your Lordship that the problem with regard to 39B may not be such an insuperable problem. Now, Lord, I tell your Lordship why. But your Lordships are fully aware that there are powers of acquisition of private property. Lord, the power to make that law is under 246, read with the relevant entries in the lists. But if I'm not wrong, list 318 or something, of list 3 provides for the power of acquisition.
Entry 42, actually, 42 of list 3, acquisitioning and requisitioning of property. Entry 42.
Sorry, ma'am. But it is definitely a power which can result in a law with regard to acquisition. Now, Lord, the suggestion that was made by some of my learned friends to say that 39B is the power to acquire, I respectfully submit is not correct. 39B is the policy that the state has to work to secure towards. It is a statement of policy which is contemplated in 39B. The Constitution has other powers which provide for acquisition. Now, Lord, my proposition to your Lordship is this, that if there is a policy which requires the acquisition of private interests, which is done in accordance with the powers of acquisition, the problem solves itself. But in this sense, that 39B at the end of the day is a policy statement. We must work towards the policy of a distribution of ownership and control of the material resources of the community. 39B by itself does not have the power of acquisition. The power of acquisition is 300A elsewhere. Once it is acquired under the provisions of 300A, the issue does not survive. So, Lord, the issue in one sense translates to this. Will you acquire for no value, or will you acquire on the principles of 300A following the due process of law? But if that is there, the question doesn't arise. So when I request your Lordships to consider this.
39B and C also not comprehend a law. I mean, it's not a power. No, part 4 is not a power at all. Part 4 is only an object. It's hortatory, as we call it. It's a goal. But when Article 39B says that the ownership and control, the state shall secure its policy towards securing that the ownership and control of the material resources of the community shall be so distributed so as to subserve the common good.
Yes, ma'am.
Does this not also factor in the reasonableness of a law which also provides for acquisition so that you will distribute?
No, Lord, I would readily agree with your Lordship.
It would be very technical to say that this does not allow the state to justify a law of acquisition on the ground that what this contemplates is only distribution of what you already have.
No, Lord, I would respectfully agree with your Lordship. Lord, I think that would be an over-technical view, and that is not a submission I make. But Lord, the point that I do wish to make to your Lordships is that the problem with regard to private interest, that part of the problem with 39B is solved elsewhere through the constitutional mechanism, through the power of acquisition. If there is a policy and the policy translates into a law which is made under the legitimate use of 246 towards the pith and substance of 39B, adhering to all the principles of acquisition, the question does not arise.
And if there is an acquisition, it would squarely come within the concept of material resources of the community.
Yes. Now, but I'm just going to address
that is going to be distributed for the common good.
But yes. But so I'm just going to
Here
come to
it
that in a
is
minute.
distribution from A to B. That is your case.
That is once again, my lady has hit it on its nail, because, my Lord, I also have put one part about the limits of this doctrine. And, my Lord, perhaps the most enthusiastic proponent of this document, Justice Krishna Iyer himself, in Bhim Singh Ji says that the limits of this doctrine are reached when you try to distribute from private party A to private party B. And that is actually what we are concerned with in the challenge.
But that is not the question before us.
Yes, that is not a question before your Lordships. I quite see. But not in trying to assist your Lordship on what we should do and what we should say with regard to 39B. I wanted to point out to your Lordships, or 2 or 3 things in my note, but I do want to indicate the outer boundaries of this document.
Yes.
But the outer boundary of this document is it does not contemplate an exchange of these material resources between 2 sets of private individuals. No, that my learned friends hasten to add is the only question. It's the only question in the challenge which will now take place after your lordship send it down to an appropriate bench. Yes, of course it is.
Let me also not be strictly correct. The idea is sometimes you are redistributing wealth from those who have a monopoly over wealth. That's what you did that's what our land reform laws did. To redistribute wealth from the zamindars to the tillers. So it was really from one set of private individuals to another.
Well, or once again you were. No, once again. Your lordship's point is very well taken, my lord. And but the only thing I would add to that is, my lord, those acquisitions were done pursuant to the power to acquire under the Constitution and for a particular purpose, agrarian reform, which is now well known. So 31A, 31B, and 31C really can be fully understood if we read them together. But I do accept that, and Lord, that is a part of my note. Could I just read now 4 or 5 paragraphs of my note, and I am done.
Under those laws of agrarian reform, all these lands first stood vested in the state. It became community resource. Then the tiller had to file an application seeking occupancy right. And if he is really the tiller, then order is passed by the land tribunal to give it to the tiller.
I am deeply obliged to my lady.
And not directly to the tiller.
Exactly the point I want to make with regard to acquisition. That actually it is not such a problem if we intersperse the concept of acquisition. Lord, this argument which has been made thus far on my part as well, Lord, has left out that part. Lord, it is important to understand this directive principle in the context of the power to acquire. Under 300. Now, Lord, I have kept your lordship so long, Lord. Can I just show your lordship, Lord, 4 or 5 paragraphs and I'm done, Lord, with this note. Yeah. But may I take your lordship, Lord, to my note at page, just to indicate at page 124. Lord, at 124, in the first 3 paragraphs, I've dealt with the Mafatlal judgment. Lord, there I've made the point that I have made to your lordships with regard to obiter. I sought to make a second point also, that the judgment is totally distinguishable. Lord, it deals with unjust enrichment and the distribution of tax. So it is totally different. But in my respectful submission, the reference was rightly made and your lordship ought to entertain it. Now, Lord, the second set of points 4 and 5, Lord, is what I have said with regard to 300A. If I can just read my formulation in paragraph 5.
Yes.
Once the property is acquired with the authority of law, the question with regard to the inclusion of private property within the sweep of 39B falls away. The petitioner submits that the acquisition with the authority of law of private property may be pursuant to a policy formulated by the state under 39B, to my lord's point, and the distribution of ownership and control thereof may be in accordance with the principles of Article 39B. Now, Lord, some suggestions to your lordship about how we will deal with the observations on 39B, I have sought to make here. Your lordships may consider them. The debates of the Constituent Assembly with regard to 39B make it evident that the language of the articles in Part 4 was deliberately drafted to ensure they were not given a fixed or rigid form, but could be fundamentally changing, having regard to the circumstances of the time. Lord, I refer to the speech of Mr. Ambedkar. But it is relevant that the Constitution also provided for fundamental right of ownership to property, Article 19(1)(f) and 31 at its inception. The Constituent Assembly was therefore fully conscious of the fact that private ownership of property was then a fundamental right. As is well settled, it is also a part of the constitutional scheme that the fundamental rights and directive principles of state policy were to be balanced against each other. But Minerva Mills. Despite the socialist aims of the Constituent Assembly in incorporating the directive principles in Part Roman 4, private property was also respected as a fundamental right. Article 39B provides for the distribution as best to subserve the common good of ownership and control of material resources of the community. The expression material resource of the community, now Lord, this I want to stress, is a composite expression, and each word is a necessary ingredient of the same. To determine if the requirements are met, it is necessary to consider each of the ingredients being met individually and in the aggregate. But that's paragraph 9. What paragraph 10? Not the expression, so but it is necessary to meet each of the conditions individually, but also in the aggregate. So it is a self-limiting provision in one sense. It is very difficult to find something which meets each of the criteria in aggregate, all of them, not and or not one of them, but each of them for every part of this particular Article 39B. Not the expression para 10. The expression material resources of the community must also be in accordance with the intentions expressed by the members of the Constituent Assembly, be interpreted not in a fixed or rigid form, but in a manner which is fundamentally changing. Now about my submissions. Well, it is submitted that 39B has been deliberately given the language that it has to maintain its open texture, to give it flexibility, to adapt to changing constitutional and social values. But keeping with the spirit of the Constituent Assembly and the manner in which 39B has been drafted, it ought not to be limited and stroke or straitjacketed and stroke or canalized. It is preferable to test each individual case against the ingredients of 39B, keeping in mind current constitutional and social values, not to give a particular temporal interpretation to the article. Current constitutional and social values, i.e. the importance of private property, my Lord the Chief Justice said repeatedly, enshrined in 300A, and the importance to the role of private enterprises, my Lady Nagaratna referred to it repeatedly. The sweep of Article 39B provides that the distribution must be to best serve the common good of all. All of these considerations must be cumulatively considered on a case-to-case basis, but the aspect of community was repeatedly stressed by my Lord the Chief Justice, by my Lord Justice Dhulia, repeatedly, that it has to have a community element to this. The limits of 39B may also be borne in mind. Justice Krishna Iyer himself in Bhimji Singh's case stated that the whole story of Ms. Agarwal, Ms. Jetmalani, and Ms. Bisni are a part of the team who worked very hard on this. My learned solicitors, Mr. Jadeja and Mr. Unikrishnan, and of course, my learned seniors, who your lordship will.
Thank you. Please give our compliments to the entire team of your juniors who worked very hard.
Deeply obliged, your lordship, but it's been a great privilege for us.
That's it.
Please.
My lord's permitted, sorry, can I?
1 second, my learned brother.
That's it.
No, Mr. Endeavour, I think you are leaving for Mumbai today, right?
But I don't have to, if your lordships want me to.
No. In fact, perhaps when you go back home, you have young children,
I do, madam.
all right, they might ask you, Papa, what were you doing in Delhi? Right, so you will say that I have gone and argued a case. So the children is curious, might say, what was the case all about? You can't be talking to him or her, 31C, 39B. You will say that we are discussing a case which related to cheese. The other side, the uncle from another uncle was saying that the cheese had sweet cheese, it had holes. I was saying that it was a Amul cheese which does not have holes.
But I take your lordship's declaratory point on this, but I treat it very seriously. I'm deeply obliged to you.
Let's. Yeah, I
request a clarification. Petition 660 and other petitions relating to Rent Act, we're also on board, my lord. Just like to know.
We are going to answer the point of reference with a bench of 9 judges, and thereafter it will be placed before the regular bench for hearing the challenges.
Could I make a small prayer, my lord? Not done before constitution. But given the fact that these have been languishing from 92, my lord, till today, and they're still getting 1940.
After the reference is disposed of, you can move the Chief Justice in the administrative capacity, and the matters will be listed assigned to the regular Two-judge or three-judge bench as the case may be.
Lordship, I wanted, my lord's
It will
comments.
have to go before a regular bench, right? Three-judge bench, doesn't have to then go before a five-judge.
Yes, Lordship, I wanted 1 minute of my lord's time, if my lord's permit. There's a note 1I. I just wanted to point out what are the 4 points I've made. I'm not going to argue them, but just to place them. One, my lords, on 31C we made, I've described, etc., and given details. That was a short, so to say, departure of the balance between part 3 and part 4. From 1971 to 80, 71, 31C came in, and 1980 it was declared void. So there is no vacuum or void. It was for a very short period of 9 years that it survived. Then on 39B, I have also given the rules of interpretation of constitution, harmonious construction, etc. I just want to make one last point, and that's I'll close at that. I've described all this interpretation of 39B, but what 39B says is so distributed. It doesn't say distributed. Now, so distributed, as many of my lords mentioned, for example, airwaves. Airwaves, only 2 players is for the common good. Electricity, sometimes a monopoly is for common good. In some cases, it is many. So distributed is not what the respondents argued, namely give it to everybody.
No,
You can't. So therefore,
argue that at
you
all.
have to see what is in public interest.
You
And
can't
therefore,
dispute. I mean, these are, the
Lordship.
spectrum has to be necessarily, it's
Lordship.
always.
Absolutely.
There are 2
Facts
players.
and context.
Therefore, in my note, I've given using the rules of interpretation of a constitution, I've given my submissions on 39B. And
Plus, we just wanted to seek indulgence.
That's-
That's for
and
2
let-
minutes to.
My lord's
make
kind
us-
permission, my lord, the community should be assigned some meaning in the sense, a group of persons who do not have potential other than the policy of the government. And one thing, that by the time the Minerva Mill and the Vaman Rao were pending, 44.
What do you have to say?
Well, we just wanted to point out one important phase. There is a comparative constitutional law question also involved here, Millets, because the original Irish constitution from which we have taken Article 39B has a near identical provision, Millets, and that has been interpreted by the Supreme Court of Ireland by giving reference to our provisions also, Millets, and that is quoted at my volume 2P for your lordship's consideration. And Millets, the second part of it is under 2T, T for technology, where Millets, I have only requested your lordships to keep the expression as fluid as possible because of the changing dimensions of technology. Namely, Millets, there could be an open source. There could be a specific, Millets, there has been 100% FDI investment in space. And very recently, the first private satellite has gone out. So there could be mapping constraints. There could be constraints in respect of finding out as to the crop rotation schemes, etc. So that particular information which is tabulated by the satellite also, over that, perhaps the government might want to exercise control at some point of time for the purposes of distribution in order to facilitate the farmers to know as to how exactly the crop functions or whether there would be a monsoon, etc., etc. So the scope and the width.
2B, right? 2B.
The first is 2P, P for preamble, and the second is
2T.
the second is 2T, which is what technology. I am Nipun Saxena.
So, my lord, may I say a few words?
2P.
2P, P for preamble, and 2T.
And 2P for.
And 2T. I'm so.
So, my lord, may I conclude by one word? The impact of the Minerva Mill and the amendment of Keshwanand Bharti, the speciality attached, the saving or the immunity was taken away, and it became reduced to a normal directive principle of state policy, which cannot give a better right to the government. That remains, and lastly, one judgment of Justice B.V. Nagratna, 2023. No.
With Justice Joseph, right?
Yeah, with Justice Joseph.
That's been
Lordship,
cited.
my submission.
That has been, and now lastly, what I say.
2C and 2J, my lords.
2C and 2J.
2C. By Varun Chopra, my lords.
This will load by tomorrow.
Yes, sir. Thank you to all of you, and we thank you very much for all your assistance.
I'm so grateful. We have completed our hearing before dynamic and young Chief Justice.
All of you. Thank you as usual for all your very comprehensive.
As usual, state of West Bengal.
It's the compliment.
What?
They have argued before a dynamic and.
We have argued before Honorable Dynamic and Young Chief Justice. that stands for D and Y. Great one.